Yes.
Item number 18, Your Lordship.
Number
18.
18.
Representing Petitioner Council, Your Lordship, may taken up after 2 weeks.
Post after 2 weeks.
What's your plan?
28 suspension is already listed, sir. Further
28, sir. You are for the petitioner, sir? Madam, Learned Counsel for the petition informed this court. Can you have the interim order?
Let's see. Item number 24 and 25. Let's see.
24 and 25.
All questions are requested. 1 week time. Let's see.
Post after 1 week. Informed other side? Government, huh?
I will inform.
Informed, not informed.
Not informed.
Okay.
Much okay.
item number 62, my lord.
62, sir. Yes.
There is no further orders are necessary. It will become
Interim order
infectious.
is there or?
Infectious.
The Learned Counsel for the petition informed this court. Thank you, sir.
Oblige.
Item 50 minute may make.
Item?
50 minute, 50 minute.
Yes, sir.
Last May out after 2 weeks minute, I need to carry out some amendment. I need to file an amendment petition.
Post after 2 weeks.
Obliged.
Yes, sir. One slip, one counsel.
Last occasion that was on 6th November. Petition 2129, visually handicapped. My Lordship has asked the other side to see whether any vacancies are there. There are vacancies, my lord, but the matter your lordship has posted for Wednesday, but the matter has not come. So I'm requesting that your lordship may.
It will come, madam. It will come. No need to. For that also, what's the purpose, man? It will come. ఏమండి కోటేశ్వరి గారు అది మ్యాటర్ మొన్న అయితే ఎందుకు రాలే మరి మొన్న ఫర్ వాట్ పర్పస్ ఇట్ విల్ కమ్ నేను హార్దిక్ లిస్టెడ్ ఆన్ లాస్ట్ అకేషన్ నౌ ఇట్ విల్ కమ్ అగైన్
Yes, I'll
Just to
this
give a-
number. They can.
సో అడగండి వై ఇట్ వాజ్ నాట్ పోస్టెడ్
I'm highly impressed.
ఎస్ give some time to register. While your bundle is tracing out or not, we don't know. Wait for 1 week or 2 weeks, then again is mentioned. Otherwise, your feeling will every day we are mentioning, it's not listing. That is your feeling. That will be your feeling. So wait, sir. As to, according to you, it has to listed it yesterday, na?
Court number 18.
Okay, wait, next week you mentioned. Yes,
Subject to losses kind.
Huh?
2018 matter, not
only
one.
one matter.
It is equivalent.
Is the bottom main age for
The reason is because of closure of the place, this person, client advocates, particular service lawyer are facing.
మీరు మొన్న మెన్షన్ చేసింది వచ్చిందా లిస్ట్ లో
రాలేదు.
ఎందుకు రాలేదు
ఇక రిజిస్ట్రీ అట్లా పనిచేస్తుంది. ఏం చేస్తుంది మేము పోతేనేమో వాళ్ళ అడ్వకేట్లు వస్తున్నారు సార్. అంతా వీళ్ళు ఏం చేసిస్తారంటే అవుట్ సోర్సింగ్ వల్ల పెట్టినాడు ప్రాబ్లం వచ్చింది మాకు. మార్నింగ్ ఒక టోకెన్, మధ్యాహ్నం ఈవినింగ్ మార్నింగ్ ఒక్క ఫేస్ ఒక రోజు ఉండదు, తప్పించుకొని తిరుగుతున్నారు. ఏం చేస్తాం మేము? ఇది ఉంటే కనీసం మా క్లర్క్లు వెళ్ళి లైసెన్స్ లేకుంటారు అట్లీస్ట్.
ఒకటి ఇవ్వండి
ఒకటి
మండేకి ఇద్దాం
ఎనీ డే బిలాంటి లైసెన్స్ కన్వీనియంట్.
స్లిప్ తీసుకోండి ఒకటే తీసుకోండి ఉండొద్దు
డైలీ మేము ఎక్కడ మెన్షన్ చేస్తాం
ఏది అర్జెన్సీ చెప్పండి
అదే చేస్తుంది.
ఓకే మండే
నాకు వచ్చి ఏం చేసిన 2-3 స్లిప్ వేసి అవుతాయి అంటే ఎట్లా మాకు? మీరు సర్వీస్ లో ప్రాక్టీస్ చేసి మాకు ఎంత హెడేక్ ఉందంటే హెడేక్ ఫేసింగ్.
అలా కాదు, నేను ఇస్తే అక్కడ రాకపోతే మళ్ళీ అది నాకు హెడేక్.
ఏముండదు, విల్ టేక్ కేర్ ఆఫ్ దట్.
అది టేక్ కేర్ తీసుకుంటా.
అంటే కనీసం ఇది ఉంటే ది క్లర్క్ విల్ హ్యావ్ సమ్ లైసెన్స్ టు ఇంటర్ప్రిమైజ్, అదర్వైజ్ వీఆర్ ఫేసింగ్ లాట్ ఆఫ్ ప్రాబ్లమ్. ఐ నెవర్ ఎంటర్ దిస్ రిజిస్ట్రీ ఈ పీకెట్ ఇప్పుడు నిలవాల్సి వస్తుంది.
ఒక నెల ఎవరు ఎన్ని స్లిప్ దాన్ని పర్మిషన్ ఇద్దాం అయితే.
ఇక్కడ మండే హాలిడే.
ఒకటి మండే
మండే
మనం.
Subject to allotment permission, my lord.
Yes, sir.
To WP number 27748 of 19, my lord. Matter preference not granting pensionary benefits, my lord, is retired in 2016.
Repeat
Any
once again,
date in the
sir.
next week, my lord. WP number 27748 of 19, my lord. Any date in the next week, my lord.
Okay, next week. 2018 matter,
19, man. 19.
after 2 weeks.
Oblige, my lord.
Item 32, my lord. Matter has become infructuous, my lord.
Item
32.
you are for
I am for the petition. 32, my lord. 32.
32. That's what I am saying. 32.
Yes.
Learned counsel for the petition informed this matter become infructuous. Dismissed as infructuous. Yes, Ramakrishna.
My lords, this is Ramesh Chilla, my lords.
Post after 2 weeks.
My lord, WP number 6790 of 2020, my lord.
Post after 3 weeks.
My lord, it's on December 5th.
Let's put fixed time. 18 matters next week. 1 week.
And batch matter of 18 and 19 matter.
3 weeks.
It's already on December 5th, my lord. They have CAS interview.
Give first one slip for one case. After 2 weeks, will come. This one go down.
My lords, this is Ramesh
Only
Chilla, my
one
lord.
slip, no 2 slips. Yes, sir.
My lords, the writ petition number 4796 of 2020, it's supposed to list on 31st October, my lords. It was not listed, my lords.
Once again, repeat, sir. Repeat, sir.
Writ petition number 4796 of 2020.
Post after 3 weeks.
My lords, it's supposed to list on 31st
No, this
October.
court fixed. This
My
court
lords,
fixed 18 matters 1 week, 19 matters 2 weeks, 20 matters after 3 weeks.
I agree, my lord, but it's supposed to list on 31st October, my lords.
After you confirm from the register, your bundle is tracing out or not.
No, it is there, my lord. It's there,
Then
my
it
lord.
will come automatically. Don't worry.
Oh, bless me, lords.
My lord, it's already on this 5th of December, my lord. And 3 weeks will be
Yes,
more.
sir. Even one slip, no? Be happy.
That's obvious.
MACM is partly allowed. Ian? Sir, docket చూడండి లాస్ట్ టైం వచ్చాడా రాలేదే? Okay. Who is appearing from other side, government side? Anybody is there for government? ఏంటి? Dismissal deed for non-person. The matter is coming that under the caption of dismissal. This response is option. Department non-person. రవీంద్రాల కుచి రామ్ గోపాల్ రావు this would the same dismiss for department non-prosecution. Same, this is also.
I am representing a Balkrishna Lordship for complaints.
Who is appearing other side? Government.
One,
All who are appearing in this court from on behalf of government, you take the authorization letter from AG. You have to represent all the matters, all the departments. Because nobody is coming in this court. Pass over.
sure.
Short pass over. ఎందుకమ్మా why? Okay, short pass over.
That only the entry
One
person
case you are implemented order some one case, you are not in this case. Why?
in para 2, last page 2.
ఆయన వచ్చినా చేద్దాం నేను ఎందుకు మీ ఎనర్జీ వేస్ట్ చేసుకోకండి.
Should this matter, they requires a counter, they have not been filing a counter. Lordship,
Okay, post after 2 years in usual course.
my Lordship, I am the petitioner.
So what?
My Lordship, there's an urgency in the matter, but they are not filing counter.
Again it will come order. What is the purpose?
My Lordship may say, if they do not file a counter, the matter will be
I
heard.
think it is there already. It is there.
Lordship may not put in usual course. And the last chance, I will argue
Usual course means next. When do you want? 1 week or 2 weeks?
1 week.
1 week, next week it will come.
Usual for orders caption.
Don't go for olden days. You are in 21st century, every day, every case, every time will come. No question of.
Lordship, only one chance in for orders. I will take a chance. I'll argue the matter if they're not arguing the matter next time.
You ask them to file counter, again I'll put it for orders. By the next date of hearing, if they won't file counter, I'll post the matter after 4 weeks.
No, I'll argue the matter that if they do not file a counter, I'll argue the matter with
It will
you.
come. You see, it will come.
Humble request.
No request, that is your right. It will come. Don't worry.
Orders.
Not required.
Save my caption.
Not required. Pass over.
But this is that matter where medical
Examination conducted.
he says that he was
If he is not
invalidated.
qualified,
Yeah.
you have to arrange the alternative dependent employment.
No, but still the problem would be, let's say, the 2 years leftover service is not there. He will not be able. He is not eligible for dependent employment. He says that Surendra Reddy, I verified with Surendra Reddy. He says that his client was medically invalidated. But the issue was that 2 year service was not there. We are not even referring to medical examination because there is no point, because he will not be entitled for dependent employment.
Correct.
Court said because of that not sending him for medical examination is wrong. Then we send it for medical examination. That doesn't mean that he is still entitled for a dependent employment, because the circular that
If he have a 2 years of leftover
service, then only he will be eligible. That is the reason why all batch of matters have passed on the last occasion. All matters were closed matters. If he has any, he has to challenge that circular also, which says that only 2 years of leftovers that has been upheld by
pass over పెడదామా?
instead of passover some other.
Pass over పెడదాం. మీరు
Today lot of
what he said, pass over. Pasnuri Ananta Atreya. Your name is this, sir. You are a pension counsel. Yes, sir. Yes, sir.
Non-disposal of IA. CRP 5.
You are the defendant in suit or petitioner in suit?
Petitioner is filed a suit for injunction. The Honorable Court is senior civil judge of Vikarabad, injunction order also be sanctioned. Given the injunction order, not to interfere of suitable property. There again, respondent interfering the suitable property controls the this land and filed a IA.
Who filed IA?
Plaintiff.
Plaintiff filed IA.
IA. Appoint the advocate commissioner and demarcate the boundaries and survey may be conducted. Both sides, petitioner and respondent arguments also are. And then after also,
When the IA was heard? On 3/6/2020.
3/7. And injunction order granted.
3/6 injunction orders to issue.
Yes. And the argument is heard 23/6/2020. Respondent of petitioner argument. Then after, the Honorable Court is pending the IA and issues framed posted to trial.
When the posted matter was posted, when the matter?
17/11. Docket order also, HIGHCOURT docket order filed.
Is the docket order?
Page number 6 here. Both parties and following the frame for trial, whether the plaintiff is entitled for the purposeful injunction in respect of the schedule law. Against the defendant, witnesses within 15 days and for the trial, 17/11. And kindly see your answer. Clearly stated order 26 rule 9 is a procedure. Here CPC. And our own Honorable High Court citation also given the lower court. Kindly see your.
What is Rangan?
There is no absolute bar for appointment of advocate commissioner suit for injunction. Simplicity.
Use mic, sir. Little bit loudly. I am not able to hear your voice completely.
The Code 1908, Section 75, Order 26, Rule 9, appointment of advocate commissioner. There is no absolute bar for appointment of advocate commissioner in a suit for injunction. Simpliciter, either in the course of trial or during inquiry, in a temporary injunction, petition the trial court by virtue of the power vested under Order 26, Rule 9, CPC, appointed advocate commissioner to visit the suit schedule property, localize the schedule and A and B property, and also to localize the property covered by the registered sale deed dated 28/1965 with assistance of the qualified surveyor, and also to note down and physical feature of the property with a caution that not to mention to details of the persons who are in possession. There is no absolute bar on appointment of the commissioner in suit for perpetual injunction, either as per the provision of section 75 or order 26 rule 9 CPC. Is clearly stated, Your Honor. I am the file IA, order 26 rule 9. Appointment of advocate commissioner. Only dispute is between the plaintiff and defendant, extent dispute. The survey is conducted, come out the true fact. What is it? And respondent also
For the plaintiff, you are seeking the survey.
survey. Appointment of advocate
But
commissioner.
initially you granted interim injunction, right?
Yes, Your Honor.
Then once interim injunction is granted, where is the question again survey?
Again, approach the suit schedule property, not to having this 1 acre 10 guntas, plaintiff schedule property. The petitioner is 10 acres sold, out of 11 acres 10 guntas. Remaining 1 acre 10 guntas is not having the suit schedule properties stated respondents. I am the filer IA, survey the conducted and come out the proof fact. And respondent also, WS filed, kindly see Your Honor, last page.
File IA.
WS.
Assume that you filed IA for collection of evidence only you are asking. IA survey. IA survey. For collection of evidence you are asking that IA. That's what I am asking. What do you say?
Sir,
Collection of evidence. I think you don't have the evidence to prove your substantial property. For once the demarcation is over, you will get some.
old passbook, new passbook also filed, Your Honor. Old passbook is 11 acres, 10 guntas, this survey number 31 rule. And sold the 10 acres. Remaining 1 acre, 10 gunta, new passbook, e-passbook also given the authorities.
Okay, take out personal notice.
Personal notice.
Post after 4 weeks. File proof of service. Main case, no issue notice, madam. Complaint, huh?
Item 10, Malad.
Yes.
Item 10, Malad, in spite of service of notices, they are not, respondents have not appeared either in person or.
The respondents are saying no, orders are complaint.
No, they are not complained, Malad. They are not complained. That's why, Malad, let them file a counter. They have not complained the order.
No, they are saying complaint.
No, you'll also kindly see the order. You'll also kindly see the order. Their order is suspended.
One second, order this one.
46, Malad, page 46. But the imprint order is suspended. Once suspended, Malad, they have to follow the old order.
No. What is the interim order, sir?
Malad, you'll also kindly see, Malad, suspend the operation of the proceedings dated so and so the second respond pending disposal of the writ
Where is
petition.
that interim order?
That interim order page 46.
Page 46, huh?
Yes, Malad.
Hmm.
Last get Malad.
There shall be interim suspension as prayed for.
Yes.
What
That
is
means
the
there
interim
is
suspension as prayed for?
pervert that is Malad, that also page Malad, that are file Malad. That is Malad, page 39 to 41.
Suspend the operation of proceedings so and so.
Yes, sir. That is Malad, 18/7/2020.
1 second, sir. Yes.
They are refixing my salary, Malad, in order to recover the amount. Page 39 to 41, Malad.
No, you received the 9/2021 proceedings.
Malad, that Malad, they ignoring the impugned order, they passed it, Malad. They
No, in
following the
compliance to-
impugned order.
Kindly
That
listen,
means,
sir.
Yes, Malad, 1/12/2021, they have passed, Malad. That is contrary to the order of the Supreme Court.
No, in the order says that the operative for in complaints of the orders of the Honorable High Court, the orders issued by reference first cited above regarding regulating the AGIC's individual and recovery of excess amount in the cadre of TGT mass to C Ganesh, TGT mass so and so. Ranga, it is hereby paused temporarily until further orders of the Honorable High Court in WP number 11430 of 2020.
That is the order of the Malad, second respondent. But Malad, the other Malad, his subordinates are passed order, Malad. Ignoring that, they passed order.
Kindly wait some time, sir. Tell me, sir. This is not the according to is not.
Let them file a counter. Let them appear, Malad. My land friend cannot appear.
Is that a writ petition? Huh? No, Mr. Counsel.
Yes, Malad.
The once vacate stay petition is filed, vacate petition has to defend first of all.
Unless Malad, vacate is granted, Malad, they cannot say that my order, Malad, simply filing a vacate stay petition.
It's for vacation of interim order, not absoluting of the interim order. Once vacate stay, when you file vacate stay petition, sir? Prior to content of the, is it correct?
Well, they
Vacate
they
stay
have not
petition
pursued
is,
the-
kindly listen,
that-
Mr.
that-
Counsel. Vacate
that-
stay petition is filed before filing of the content or after filing of the content?
my lord, that they have not pursued the millet. They have not
Yes.
pursued the lead order.
Answer the question, don't say other things. I am asking one question to you. Vacate stay petition is filed after filing of the contempt or before filing of the contempt?
But they have not served the copy before the millet filing the contempt, and they have not pursued that matter.
I am
They are
posting
not
the matter, this contempt next week, physically append will argue the matter then.
Yes,
Post-
millet. Yes, millet. Yes, millet. In second,
This
in
is after
second
post
case-
after 2 weeks, it is under consideration.
yes, millet.
Respondent counsel telling this court, it is under consideration, I am posting the matter after 2 weeks.
The second matter, millet.
Yes,
Yes, millet. That is yes, millet. The
Which
first
state?
respondent has to consider.
yes.
Yes, millet.
Signed an affidavit. Today the matter is stayed with the Honorable Supreme Court at serial number 21.
Next week, post next week.
And I have also,
Tuesday.
may I request one, I have filed an affidavit to
No,
this.
today it is listing the bunch, huh?
Yes,
No, I think whatever it is, result will come out evening.
yes, then I have also,
Tuesday is not okay for you then.
yes,
Tuesday, post on
I
Tuesday.
have also filed an affidavit to the effect that I need, in case.
Post on Tuesday, sir. No issue. Yes, yes, Tuesday. Okay, Thursday. Thursday, okay, agreed. మాకు కావాలి ఆర్డర్ ఇటు అటు అయిపోవాలి పెండెన్సీ ఉండొద్దు.
Right, please.
ఎస్ సార్.
Petitioner, before your lordship, while he was working and discharging his duties in the international airport, charges were leveled against him that Miller's some stamps.
Who is appearing other side? Counter is filed.
Counter is not filed since 2019. Now he is seeking for his pension and all of things.
Who is appearing? Sir? Nobody. GP for home, who is appearing? ఇప్పుడు ఉండేదా చంద్ర ఇక్కడ? ఎందుకంటే టైం వేస్ట్ అండ్ ఎనర్జీ వేస్ట్ ఇది. No, no, Chandra is kindly so. Chandra is there or not? Just to, Chandra. Then we'll pass over then. Come. And counter also not filed. We'll post it on Tuesday again. Post on Tuesday. Pine పెట్టాలి. Yes, sir. Who is appearing?
Item number 14, my lord.
Item number 14. Yes.
May please your lordship, my lord.
Yes.
This is with regard to my lord, appointment of the my lord, home guard as a constable, my lord. He was selected in the list, my lord, but his case
Counter is
was
filed. Counter is filed, sir.
counter is filed, my lord, on the earlier occasion before this honorable court, my lord. The matter was posted for instructions as to the leave certificate, salary certificate of the fourth respondent, my lord. On the earlier bench also, my lord, It was, my lord, coming for instructions, my lord, whether there are vacancies or not, my lord. But whenever the case comes, my lord, they used to remain obstinate. This is the practice, my lord.
My practice is that without hearing others, I won't say anything.
And that is true. That is true, my lord. Even before this honorable court also, my lord, they used to remain absent, my lord. At least this may be posted next week, my lord. This may be posted next week.
Tuesday.
Yes, my lord.
Tuesday.
Yes, my lord. Yes, your lordship, please. Yes, my lord.
No. According to your convenience, we'll post.
No problem. my lord.
Tuesday.
I am always, my lord, make myself convenient, my lord. I am
Okay,
very
post
much.
on Tuesday.
Yes, my lord. Oblige, my lord.
Respondent counsel absent. Last several occasions also he is not present for this matter. Post on Tuesday.
Oblige.
Item number? Yes, sir.
Item 15 and 16
Yes, sir.
go together, my lord.
Yes, sir.
In item 16, I am for the writ petitioner, whereas in item number 15, we filed an application for impleadment
Yes, sir.
in IA number 1 of 2020 and also filed an application in IA number 1 of 2023 seeking direction. But the writ petition,
Venkana is not available, sir, now.
but the urgency is, my lord, he filed a writ petition.
ఓ ఇక్కడ
saying that
16 కదా బిడ్డ, నేను అక్కడ 16 అనుకున్నా.
I think there is some crosstalk, my lord.
Yes, yes.
My lord, he filed a writ petition complaining the action of the respondents in not disbursing the retirement benefits of his wife. My lord, my client is the son of the deceased lady. He filed an application for appointment as for on grounds of compassionate reasons. My lord, this was not considered and that was not considered. Both have approached the High Court by filing writ petitions. In the meanwhile, my lord, what happened was the husband, the writ petitioner in 26804, is now, my lord, pressing the department for disbursal of the terminal benefits. That's the urgency, my lord. Therefore, I request your lordship's indulgence. We filed an application seeking direction not to disburse in IA number 1 of 2023.
IA 1 of 2023 is there?
Yes.
Who is appearing other side? Director Police Communications.
Well, GP for home must be the counsel representing the official respondents.
But Venkana is not there. How can I pass that order in action? We'll say pass over, sir.
Or else on Tuesday, my lord, if your lordship feels
Okay, post on
convenient.
Tuesday.
Oblige. Your lordship may record his absence, my lord, so that it will be
Yes,
convenient for
petitioner
you.
counsel absent in the first matter.
Oblige.
And post the matter on Tuesday. Counter is not filed. Okay, when do you want? 2 weeks. Post after 2 weeks. Sorry. We dismiss it for default. Dismiss for default. Under the dismissal caption, na? Dismiss for default. Miss Chilla. Counter is not filed seeking time. What do you said, Mr. Ramesh?
No, Millets. That's not at all acceptable, Millets. Millets, I'll kindly consider my. In 22nd court, there are 8 times it appeared. Just for tomorrow or we are in hands. The counter is in our hands. Just for signatures and all. So every time they are seeking time. And in 12th court, there are 2 times. And 22nd court 8 times. And 35th court, your lordship court 2 times. So therefore, it is unacceptable, my lords.
Yours is
In
that
any
much
case,
of
it is
big
not.
case. What do you do?
Pardon,
Yours
my
is
lord?
that much of big case.
No, my lord, it's very simplest of, no, your lordship, this one, my lords. No, my lords, only thing is like, no, the petitioner, the government introduced a new course, and that one discontinued.
One second,
So
one
kindly
second,
come
sir.
to the 21st, no, 21 page, my lords.
Sir, one second.
Sir,
Sir, respondent counsel on 12/10/2023, no counter is filed till today. Learned standing counsel for TSHC shall file counter on the next date of hearing. And then what is the problem after that? Again, 1910 listed, list on 8. 911 listed, one list on 1011.
Because I took the metal.
What is the problem to file counter?
We didn't have the metal from my lord. I have taken the metal.
No, if you have any problem, tell us, we'll call the officers. What is the
No,
problem?
I informed them, my lord, to file a.
Ramesh,
Sir.
I'll record the submission of the respondent counsel.
Sir.
First after 2 weeks. Meanwhile, if they won't file any counter, matter will be taken on the merits. Okay.
Oh, deeply obliged, my lord.
The
Deeply
request of respondent counsel, post after 2 weeks. Yes, sir.
Petitioners before your lordships are the retired employees of Ravindra Bharati, which is an instrumentality of the government, your lordship.
Yes.
The retirement benefits,
Counter is filed, sir.
everything.
Who is other
Counter filed instructions are
Ready?
is appearing.
File in the ready.
Counter has been filed. I have filed the reply.
Counter is in the Malinki instructions, sir.
Counter filed and sound report directed. That me can see the docket because my senior counsel stated that as per rule 20, rules of Ravindra Bharati. Let me not rules. I will argue. Then you say that no rules.
Yes, sir. Yes, sir. Yes, sir.
Because it is an instrumentality of the government. They are entitled for the separate rules are been, the statutory rules have been framed. That is called as Ravindra Bharati service rules. You will occupy that page 56. You will occupy. And the relevant page is 60, rule 16. They are entitled for gratuity amounting to basic pay for 1 month for every completed year of service subject to maximum of 25 months. This is. Then general rule you have to page 60. Next page 17 you will have to. In all matters where it is not specified in the service rules above, the AP government fundamental rules will be made applicable. Here specified how to get the gas is specified. Now, instead of paying the gratuity on the basis of this rule, they are paying the gratuity on the basis of the GOMS 99, which is not applicable to me. You will ask me GOMS 1949.
Page, sir.
49. Exhibit P3, 13.
49 page number?
Page 49. Exhibit P3. P13.
Oh, yes.
99 unit. Second page.
Yes.
10th Pay Revision Commission submitted its report to the government on 29/5/2014 and recommended inter alia to the effect that the maximum limit of retirement gratuity be raised from 8 lakhs to 12 lakhs. This is the GO, your lordship. Now,
they want to follow this GO.
They are following this GO. 1 minute. Don't disturb me at any time.
No, I'm asking him.
I'm facing I'm asking we have paid that amount of
I'm asking him, please sit down.
Why he wants to interfere in the middle? Having so much service, why you don't talk, counsel. Only you, after, when both asking you tell me.
Section and I will find the counter offer.
Ah, where is it? Already instructions are over. He has taken time for instructions.
We are not.
ఇంకా సీనియర్ ఉంది కూడా
No, no, we are not.
ఎందుకు ఇంటర్ఫీర్ అవుతావు నువ్వు?
రామారావు గారు.
నువ్వు ఎందుకు ఇంటర్ఫీర్ అవుతావు?
Listen to me.
అయితే నీ టర్మ్ వచ్చినప్పుడు వస్తుంది. నేను మా ఇంటర్ఫీర్ చెప్పు తీసుకుని కొట్టు. నేను మా టర్మ్ వచ్చినప్పుడు ఇంటర్ఫీర్ అవుతాను. This is the High Court. I got nearly 50 years of practice. I never seen such a people. Why should you interfere when I am arguing?
Government Peter in this court also. You know.
I am not saying that you have got every right to. You have got every right to. But only to when I have because these people are not trained.
No, no, sir. We are not kids.
Philosophy.
We should not repeat what is the validity of the time and the discipline maintained.
I am arguing the matter. Why should you interfere in this?
Telling me, sir.
I have already paid 12 lakhs. Who is objecting for that? You have paid 12 lakhs. For that only I am before this court.
Yes.
If you have paid 12 lakhs, then only I am before this.
Yes. So they paid
12 lakhs.
They paid 12 lakhs.
Yes, sir. To whom this applies?
Yes.
Question is to whom this applies? Whether it is applies to instrumentality, where it has got to separate this one. Page 50, para 4 you have. And we have not paid the pension is not there for these people. You know. No pension.
Read, sir. Read, sir.
The order shall come into force with Act 2014 and shall apply to government servants, including the retired university and government aided colleges who are drawing UGC pay scale in the state, and to all non-government service pensioners. I am not a pensioner.
You are not a pensioner.
I am not a pensioner.
And you don't have the UGC pay scale.
And where whose
You are not fit into rule number 4, sir. You are not anyway. You are not fit into rule number 4.
No, no, no. It will not apply to me.
Okay. Yes.
Because I have no pension. And second is my rules itself says that where it is not prescribed, government rules applies.
Yes, is correct. But here, these orders shall come into force with effect from 2/6/2014 and shall apply to all government servants. You are not fit into this area?
All government service pensioners.
No, no, sir. There is shall apply to all government servants, including the retired.
Not including, sir.
No, no. That first of all, it is applied to all government servants.
Yes. No, no, no.
Next place. Sir.
No, no, no.
Including.
No, no. There is no comma. There is no full stop. Okay, you have to read completely. Even reading that, even according to your lordship reading, your lordship reading is not correct. But even taking into that is the correct one.
No, sir.
I am not a pensioner.
There is no comma, but there is a.
I am not a pensioner.
Which gives some gap, including.
Including pensioners. I will take it. Even though there is no comma, no full stop, I will take no and. Then I will take it and service. And pensioners. I am not a pensioner.
Sir, at least.
I am not a government servant. I am not a pensioner.
Ramarao, for my
service pension is being
including the retired university, government, aided college teachers who are drawing the UGC pay scales in the state, and all the non-government service pensioners whose service pension is being charged. Yes, 2071 pension and other retirement.
Yes.
Who retired?
All government servants pensioners, as you will also take it.
According to you, this rule is not applicable to you.
To me.
Yes.
This GO will not applicable to me. For two things. First thing is I have got a separate rules. Under general rules of that rules clearly says wherever it is not prescribed for services matter, government service rules applies. One more time, sir. Maybe repeating.
Once you have some rules with regard to pension, they have to apply that rule only.
No, that rule only. You have page. Page 60, bottom you have to. Rule 16, gratuity. This is regarding the gratuity. Gratuity amount to the basic pay for 1 month for every completed year of service. Subject to merit demands, this pension I have to get it. General rule clearly says
If applies this rule, how much amount you will get?
I will get to nearly 18 lakhs of them. And another, because the 3 persons are there, various posts they have retired. So I pay 60, your lordship. General. 17, rules 17.
In all
matters, where it is not specified in the service rules above, the government fundamental rules will be applicable. No, I have got a gratuity separate rule. Fundamental rules cannot be applied.
Yeah, no, I understood, sir. Kindly wait some time. Yes, sir.
1 minute, your lordship. For this purpose, when there is necessary the counter, instructions, everything, what is necessary? We have to show only, yes, yes, no, this GO applies to you. I am more interested.
తెలుగులో సామెత ఉంది సార్. ఇప్పుడు మీరు ఆకలి అవుతుందంటే అన్నం ఉండాలి కదా, అన్నం ఉండడానికి ఎంత టైం పడుతుంది మొత్తం?
There is the necessity of counters and all these things.
కౌంటర్ చేయాలి, గవర్నమెంట్
If he is able to show, no, this GO applies to you. And another, second thing is, your lordship, because purposely, even with our representations, the secretary is so adamant, so many representatives that, no, you will pay only 12 lakhs. We have explained the rule and therefore it is the fault of the government not paying their full gratuity to me. I am entitled for the interest, your lordship, 18%.
with you. Any citation you are going to show? Any citation you are going to show?
Yes, sir, citation. I have already given copies.
చూడండి కోటాస్ ఉందా?
Citation copies I have given. I am more interested in interest. Like a pawnbroker.
Yes, sir. Not there.
Photostat copies I have given. Not photostat copy.
No. Yes, sir. Not there. Read, sir. Read and give it to me. Let's see. What they say in the citation? Sir, what is that citation?
Citation first. There is 2023 1 ALT 287. Right to retirement benefits. Petitioner retired from service. Court primarily opines that respondents erroneously withheld retrial benefits. Petitioner entitled to interest on such benefits.
Your case not withheld, na? Some amount was paid.
Gratuity is a retirement benefit.
But
Gratuity is a comes under.
amount was not withheld. Some amount was
Comes
paid,
under retirement.
wrongly paid. According to you, wrongly paid, but some amount was paid. But that citation
Some amount is,
applicable.
I am not, when I have repeatedly,
I understood, sir.
this one, representations were made.
To repeat once again.
No. The secretary is so, it's not an illiterate. He's in the category of IAS officer.
Illiterates will do.
Even though he is not IAS officer, but he is the category of IAS officer. Can't he not understand the GO?
Yes. Okay.
Am I not entitled for the interest?
Sir, that's all from your side. Yes, sir. Only small question I'll ask you, sir. The according to the seniors submission.
Yes.
Once there is a rule for granting of pension.
Yes.
No need to search for other provisions and rules.
Yes.
So, basing on this gratuity rule is there in page number 60.
Yes.
Gratuity amounting to the basic pay for 1 month for every completed year service subject to maximum 12 months. So, if it is not there in your rules, in your gratuity rules,
Yes.
then second will apply in all matters where it is not specified in the service rules.
Yes.
Above AP government rule. So here there is a specific service rule is there.
Yes.
Why you are not implemented this?
Yes. So, we have already filed counter in this case because we have already paid the amount of rupees 12 lakhs. That was enhanced. No. I will try. That as per GOMS number 99, that's we can see GOMS number 99, dated 21/7/2015. That was enhanced the amount of gratuity amount of 8 lakhs to 12 lakhs. My senior counsel says that GO is not applicable to me, that amount is not correct. So let them remit that amount and ask, because we have already paid 12 lakhs as per rules. as per rules and as per GO only. And it is clearly stated in my counter also. That's my kind of see.
No, so if they will make a representation before your authority, you are ready to pay.
Pardon?
If they are going to make a representation for remaining amount, you are ready to pay.
Not ready to pay. Not ready to pay. You have clearly stated that amount is only because it is clearly stated in page number
How
4.
much you pay?
Page number 12 lakhs. 12 lakhs we have already paid. In counter also clearly stated in that. In counter page number 4.
As per the 16 gratuity,
Yes.
what is the amount you have to pay? Tell me the factor.
Pardon me.
As per your service rules.
As per service rule, 12 lakhs is as per.
No,
Then 8 lakhs, 12 lakhs.
1 second, sir. As per service rule, point number 16 under the caption of gratuity, how much amount you have to pay to the petitioners?
They have fixed 8 lakhs to 12 lakhs only. 8 lakhs to 12 lakhs only. And we get the instruction also. The Honorable Court directed last
How
time.
you fix, there is once there is a rule provision is there, how to calculate the amount is there, how you fix that amount? If it is not there, okay. There is a specific given gratuity amounting to the basic pay for 1 month for every completed year of service subject to a maximum of 25 months payment.
In every
This type of particular calculation methodology is there. How can you fix the amount?
Fix the amount that GO was issued and fix that amount of 12 lakhs only. And we get the instruction also. I placed the before you learn. Instructions dated in that 26/9/2023. As the direction of this Honorable Court only, may I place before the Lordship on that 25/9/2023 instructions that were addressed to the government leader. That's my kind of thing. Got it? Got it?
This is one, this one?
Letter.
To the government period for services.
Yes. And as per direction of this Honorable Court, that it also says that this Honorable Court directed, previously this Honorable Court directed to get the instruction from the government. That is clearly stated in page number 2, para 2. Page number 2, para 2. Which is on par of the government employees and also so having the second para, page number 2, para 2 in the instruction. In the instruction,
which is on par with the
which is on par with the government employees. Kitchen, sir, junior kitchen. No, I already sent the copy to junior. మన ఏజీపీ ఎక్సైజ్ లో పనిచేసిన కదా సార్ పిలిచి అడగండి ఇయ్యలేదంటే మనం ఇంకో నేను ఉద్యోగం రాజీనామా చేసి వెళ్ళిపోతాను.
మళ్ళీ ఎందుకు సార్
గవర్నమెంట్ చేసి వెళ్ళిపోతాను. ఇయ్యలేదంటే ఒకటే ఇట్లా ఉన్నా ఒకటే ఎట్లా ఉన్నా ఒకటే కాదు. ఎందుకంటే మీరు బాగున్నారు సీనియర్ నో రెస్పెక్ట్. మళ్ళీ ఏదంటే దట్ ఈస్ నాట్ కరెక్ట్. వి హావ్ ఆల్రెడీ సార్
దిస్ కోర్ట్ ఈస్ గివింగ్ లీనియన్స్. వి ఆర్ ఆల్ ఎల్డర్లీ పర్సన్. వి నో వెరీ వెల్ హౌ టు డీల్ విత్ ది కోర్ట్ అండ్
వి హావ్ ఆల్రెడీ గివెన్
డూయింగ్ ఆల్ లైక్
sorry because we have already served a copy to his junior AGP work.
You have another copy with you or not?
No, I will not necessary. No, I will give the rule is
very clear. GO is very clear. We should no counter is required. Even this director, I personally know him. I told him, you are
already filed the counter. Let them file the reply. I will
also file, I think.
No, reply.
Reply is a property right. This copy you don't have. Reply is there. Filed by you only.
Nothing is necessary except
yes, sir. Read the second para.
Second para, page number 2, which is on par with the government employee, is also having the special provision to work the provision insurance also 60 years. Because he worked 60 years instead of 58 years. Years is not provided to the government employees as per their superannuation of age of 58 years. In PRC 2015, the government have issued the GOMS number 99 dated 21/7/2005 limited to gratuity amount to 12 lakhs. 12 lakhs is applicable to the petitioners since they are enjoying the pay scale on par with the government.
Sir, 1 second. You issued the GOMS number 99.
Yes.
Amount enhancing the 8 lakhs to 12 lakhs.
8 lakhs.
But what we have to do, the rules is there. There is a rule, provision in the GOMS number 99.
I will
you created all the rules.
As per as per rule only, they have issued GO and they are paying 12 lakhs. That is the instruction of
They
the government.
stated in the GOMS number 99, whatever rules are there in the service rule, they are not applicable. That verbatim is there.
That's why.
If that verbatim is there, this 99 will not applicable for this case.
Yes.
Understood my point?
So I will clarify from the government and I will place before the lordship.
Simply, GOMS number 99, we have given excess amount, that.
No, if that is so, he is not.
Any
They have already.
specification, Mr. Council, kindly.
They have issued that. They have issued that.
GOMS number 99, we are, as per GOMS number 99, enhancing the amount from this amount to that amount. Wherever the rules are there, all the rules are deleted or not neglected like that. If any verbatim is there in the GOMS number 99. No amendment. If there is no amendment, GOMS 99 will not applicable to this petitioners. You have to pay as per the rule 16.
And we have paid that amount.
Remaining amount you pay.
Yes.
You calculate, I'll post them at next week. You calculate as per the 16.
Yes. Post on 20th, that's me.
Post on 20th.
With interest, that is not prayer interest. Because repeat, that is not prayer in the
Next చూద్దాం కొసర సంగతి తర్వాత.
In the prayer also, I have clearly paid. Interest must be paid. Two supreme.
రూల్ ఉంది సార్.
Two judgments.
అసలు కొట్లాడండి కొసర తర్వాత సంగతి ఆలోచించండి. పోస్ట్ ఆన్ 20th.
20th.
Two judgments.
థ్యాంక్ యూ సార్. ఓకే నెక్స్ట్
Supreme Court judgment.
ఉంది సార్, ఉంది లేనట్లు నేను, కానీ అసలే రావట్లేదు కొసర ఎందుకు పోయి టెన్షన్ అని.
You will have to ask for judgments.
కాపీ తీసుకోండి.
Interest. Because a director, I personally know the director. I told him you are doing wrong thing.
Please come with full instructions.
Sorry. Pass order, I will not be because
Yes, yes.
you are not in the pass order.
Yes, what's the matter about? Ready, both sides? Promotion given.
Teachers not working in contract basis is third one. In the sanction post, as per GOI number 16, schools have to send back procurement documents to the government. Government has deferred the proposals, teacher and other candidates. Some of the candidates have.
Under what ground they differ?
Because they are non-local candidates too, that district candidate is the post. They use for consideration for appointment.
But against their decision, what is your stand?
They differ, not rejected, differ.
Differ.
When a similar situated candidate who is not local to Mahabnagar, his case has been considered.
Yes.
And we have filed the present petition challenging the DYMS number 33, whose services have been considered for declaration.
Out of these two writ petition, one has to go again. One has to.
All has been observed. I have challenged that DO, saying that insofar as not regularizing from the rate of.
The first case is not regularizing your services.
Not from rate of on par with others.
Others. Second one is.
Second, I have not filed IM. Because both are similar. Then I have filed amendment petition challenging DYMS number 18 insofar as not regularizing from the on par with other candidate.
Yes, sir.
I'm seeking only to consolidate representation from because I have set it so that my case has to be considered on par with others.
You filed a representation, correct, madam? But subsequently they issued one GO also, no?
Before that only, that the is challenging that amendment petition ordered.
I'll direct them to dispose of the representation. Post after 2 weeks. Yes, sir. Petitioner counsel absent post after 2 weeks for counter. Petitioner counsel absent post after 2 weeks. Which matter? Notice is no objection given. Direct the issue notice to the petitioners. Post after 4 weeks. Learned counsel for the petition informed this court. And delete the name. Yes. Where is GP? Who is appearing, sir? You are ready? Tuesday? Tuesday? Mr. Counsel, Tuesday is okay. Tuesday.
Next week at 11.
Okay, next week we'll have it. Tuesday ready or? Okay, post on Tuesday. If it's not there, again we'll adjourn.
Lordship may take it up on Thursday, Lordship.
Yeah, Tuesday is Wednesday, next week session. So, yes. Yes, okay. Next week it will come, sir. This is 2019 matter, kada? Oh, no problem. Next week.
Meet please, my lord. My lord, this is the matter, my lord, in respect of seeking, my lord, notional seniority along with
This other side, counter is filed.
batchmates, my lord. She's there, my lord. I'll only two facts and I'll wait. My lord, all the petitions are appointed as a teachers, my lord, in the tribal schools, my lord.
Yes.
Where, my lord, certain allegations, my lord, while giving in a selection, some of the, my lord, same ST candidates were given a complaint. These are some fake certificates, some genuine certificates. They went to my lord government. Government is finally my lord decided that genuine certificates are separated, fake certificates are my lord cancelled. After that, my lord, in between of these, my lord, 1.5 years was my lord taken place. But all other batchmates along with these my lord batchmates, my lord, they are all are given my lord appointment orders. But who those are my lord under the my lord, this fake certificate and genuine certificate which is pending before the government appeal. But finally it was decided and they are given my lord appointment orders. Those were the applicant before lordships in the present petition.
Yes.
They were made my lord at that time my lord applications also. We are genuine and our services shall be counted from the date of along with the batchmates my lord. In these my lord, as the lordship my lord aware, there are several judgments of the Supreme Court and as well as this honorable division bench also my lord. I filed it my lord in these. I wanted to give my lord, what they asked me, my lord, give that papers. First of all, my lord, they don't have any papers. Second thing is judgments also, my lord, I'll give it to them. And one more number.
After 2 weeks?
No, my lord, 1 week, my lord, I'll ask them to. No, 1 week and say, my lord, GP.
After 2 weeks.
My lord, I contacted my lord, GP, I talked to him, my lord. Her, my lord. Only if he's covered, my lord. If it is covered, my lord, she will, my lord, next week, my lord.
Okay, next week.
Next week, my lord. I'll give these papers, my lord. This is the only case, my lord. So please just. By covering the judgments, my lord.
Okay, next
My lord, one more, my lord.
Sir, this is 2019 matter. So give 2 weeks time.
My lord. And my lord, one more case, my lord, same, my lord, which is not listed along with this, my lord. I'm giving a number.
Give it number.
That may be posted along with you. If you have pressed. Court officer garu okkasari idi.
Post along with.
Oblige.
Srinivasarao Boduluri.
My colleague is attending in this matter. My lordship may pass over.
Pass over next week.
Next week.
2019 matter. Okay, next week. Wait, time is anything? Matter was admitted or not? మరి చెప్పట్లేదు నిన్నట్లాగా. If there is no counsel, we'll admit things post the matter for 4 weeks. We'll admit post after 4 weeks. Item 30. Rule is post after 4 weeks. 30. Next. (31) MP ki Aditya.
Milords, I request after 2 weeks, Milords.
Item number 13.
31.
30 was admitted post after 4 weeks.
Milords, 2 weeks. Milords. 2 weeks, Milords. Next.
But after that. So 31 also we are 31 are not even admitted, sir. We'll admit and matter post after 4 weeks.
Milords. Milords.
Also, rule is post after 4 weeks.
The item 13 Milord has been covered up.
4 weeks. Next it will come. Only 4 weeks, not 4 years.
In this case, the petitioner filed this petition seeking a direct.
Counter is filed.
Counter is filed.
Who is other side? Everybody is appearing.
For services 1. Services 1. Counter is filed on 14.
This is also not even admitted.
Counter is ready.
I say one thing. Today we are not going to finalize the case. Other side is not ready, I think. So again it will come the same case. What I want to say, we'll admit the matter post after 4 weeks. It will come finally.
Already notice was served. Counters for filed. Now at this stage, if it is admitted,
it has to come only under the caption, admission caption only.
Yes, now the counter is filed, it can be disposed of. It is a simple matter.
They are not ready. If they are ready, I'll take up now. It's ready.
Let it be on Tuesday, Wednesday. Let it be. I will inform to them.
Tuesday, by the of the side, it's not there.
I will be there.
After 1 year.
No. One thing, Lakshmi.
Your side, this option is there. My side, that option is there.
I will be there. I will be there on Tuesday or Wednesday.
You request them
for their presence, I cannot made responsible.
Without their presence, we can't finalize the case, na?
How many times it can be adjourned for their options?
But how many years it has to come under the caption of admission?
It is for the court. It would have been admitted long back. It is notice admission. It was continued under notice before admission. Now counter is filed. Matter is ready. I am ready for reporting. This matter was heard at length in other bench.
Today, we will hear the matter.
After hearing by this matter in other bench.
1 second. What is the matter about?
Matter was simple matter. Matter filed this petition seeking a direction to consider case for promotion to post of forest section officer in terms of amended rule issued in GOMS number 33. That's all.
What they said to the counter?
They said the GOMS number 33 was the department addressed a letter to the government for cancellation of that 33. So we are awaiting for orders. As of now, that GY is not cancelled. Unless that GY is not cancelled, we are entitled for the promotion. This is only the matter. For this matters, it is going on urgent for 4 months, 4 weeks, 6 weeks. When the matters would be disposed of.
4 weeks, it will be finally closed. Either this side or that side.
Earlier also, this matter was heard at length in 22nd court.
I think in this court only how many times it was adjourned?
No, I think this is the first time as per subject to correction.
First time it is coming, huh?
Yes, ordinarily, I will not seek any adjournment in any case.
Okay, when do you want, sir? Okay, next week.
I am obliged. Simple matter, it is
2019 onward, it is only simple matter.
not all. All matters. Some matters
For
are.
closure of the cases, everybody is responsible. This is the way advocates, how the advocates are obstructing to close all the cases. It is under the admission caption. 2019 matter, 2023 also it will come under the caption of admission. You are stopping to admit the case.
But they are, now at this stage it is not.
What is this?
Subject to lots of
And the same ground it is adjourning going on every day, every month, every year.
For blood, the file counter it.
As and when mind comes,
another way.
reputation counter is filed, ready.
అంతకంటే ఎక్కువ చెప్తాను.
అందుకని మేమేం చెప్తున్నా, we will close the first step, we will admit the matter. 4 weeks it will come. I am not saying 4 years.
4 weeks, it has to be wait for 4 weeks. Even after 4 weeks also, there is no guarantee it will be disposed of.
Guarantee next week it will be closed.
But there is a possibility of, because it is simple matter.
If it is possibility, that is also possible.
After 4 weeks.
Yes.
It is simple matter. Already she was waited for 4 years.
Wait for 4 months, 4 weeks only. No, my request is that being a counsels of this court,
yes,
hundreds of matters coming under the caption of admission without admitting years together. So we have to complete one step.
Even with last my send and
So what the report say, suppose
if it is not,
you think as a person, if reports say for admission 2019 200 matters, for admission 2018 200, how it looks, or 2019 matters for final hearing 200, how it looks.
But if the counter is, if the petitioner counsel is not is absent, not quoted for ready, but then let's write it, let it be posted after 4 weeks of admitting. But I am reporting for ready, counter is filed, it was hard at length in other court. Only their argument it was urgent.
Okay, next week.
Matter of compassionate appointment, not taking. Counter is also being filed with.
You are also same argument, no question of admission, post after 1 week.
I'm appearing for respondents. Item 34, I'm appearing for respondent, my lord. I filed my counter.
Ready, sir?
Yes, Lord.
Yes,
I'm ready, my lord.
In fact, my lord, in the counter, my lord, they say that.
You want to file reply in that?
No, my lord, Lordship may close it, my lord, because already they have given a letter, page number 20 of the counter.
Page number 20 of the counter.
Yes. That rejecting the compassionate appointment.
2016, it was rejected, my lord, that was not challenged.
Lordship may give liberty, my lord, to.
This is a page 20.
Yes.
You challenge this?
Yes.
Okay.
May dismiss this writ petition, not let him file another
Yes,
writ petition
yes,
challenging that.
May I please, your lordships?
Yes, sir.
My lord, this is a matter, my lord, questioning the validity of ID number 37 of 2015, dated 7/6/2019.
Yes,
only insofar as, my lord, the court below does not direct reinstatement after finding that the termination is bad, but gives a compensation of 2 lakhs. The award is not challenged by the employer. And kindly see, my lord, page number 17, para 5. Are there, my lord, the quote below?
Yes.
States the issues. At para 5, where upon hearing both sides, the points that arise for consideration is whether the termination of an employee is illegal, arbitrary, and against the principles of natural justice. Then, my lord, at page number 19, page number 18, my lord, bottom 3 lines from the bottom, your lordship should get a conclusion like this, my lord. Therefore, it clearly shows that no departmental inquiry was conducted and the petitioner was not provided an opportunity to defend his case. Further, in the absence of any material proving the misconduct of the petitioner, I am of the opinion that the termination of the petitioner is illegal. This is a categorical finding saying that, my lord, the termination is bad. Then kindly see what the court says. It is further submitted that by the management that after terminating the petitioner from service, his service benefits and dues were settled and an amount of rupees 54,000 and odd was paid to the petitioner by way of a check. Perhaps the said amount was paid as 1 month's salary in lieu of notice. However, it is held that the removal is illegal and against the principles of natural justice, as no departmental inquiry was conducted and the petitioner was deprived of the opportunity to defend the case. Therefore, the petitioner is entitled for the benefits. But since the matter took place more than 4 years back, however, reinstatement of the petitioner into service would cause prejudice to the management. I am of the opinion that granting of the compensation would meet the ends of justice. Accordingly, compensation for to a sum of rupees 2 lakhs would meet the ends of justice. Accordingly, it is directed that the respondent pay 2 lakh rupees. This is how, my lord, the court concludes. Kindly see the order of the termination was dated 7/4/2014, my lord.
Page number?
My lord, the termination order. 1 second, my lord. It's at I have filed that, my lord, at page number 44.
Yes.
The lordship got it. Further to our letter dated so and so, calling for your explanation regarding your misbehavior with fellow employees, the explanation was found not satisfactory. Your past record shows that you have been warned against through letters on various occasions. And also you are charge sheeted for causing injury to fellow worker. Even after repeated warnings, you continue to behave in an irresponsible manner with fellow workers and supervisors, which is affecting the discipline of the other workmen. Hence, it is decided to terminate your services with immediate effect. You are hereby informed that all dues paid, etc., will be 1 month salary will be paid on 8/4/2014, and the same can be collected from the registered office. This is what they say. My lord, I initiated the proceedings, and then, my lord, the letter was given, and finally, my lord, the ID was instituted in 2015. So 1 year after the termination is given, I knock the doors of the court. There is no reason as to how you can say that I have allowed the grass to grow under my feet and therefore I am not entitled for reinstatement. In spite of the fact, my lord, that the court holds that the termination was bad. I can understand that the termination was sometime in 2014. I knocked the doors of the court in 2020 or something of that sort. You allowed so much of time, therefore I will not give you. Is an understandable defense or understandable way of dealing with the situation. And kindly also see how he comes out for the 2 lakhs. Nothing is found there.
You have taken the 2 lakhs, sir?
I have not taken, my lord. I have not taken in the counter, my lord. I specifically said they indulged in making false statements. They say that I have taken, but the document filed along with the counter, your lordship would see, that was deposited only in the court. I have not even filed a check petition for that.
Yes.
The counter affidavit says I have paid it. And even this one, that is a 54,000, my lord, I have not taken. So what they do is they credit in my account. They credit in my account on their own, and I have filed that in the reply affidavit, saying that this was a credit into my bank account. I have not taken it at all because I was saying your termination itself is bad. And after the compensation is passed, they have deposited it. I have filed a reply to the effect saying that amount of 2 lakhs was received by him is a false statement made in the affidavit.
Yes.
And then I have also stated, my lord, that they have only deposited as by way of a challan in the court to the credit of the suit or the ID. So therefore, my lord, saying that I have taken it itself is a false statement. And your lordship should also appreciate, For declaring as to why 2 lakhs is necessary, certain factors are liable to be gone into. The 2 lakhs cannot just be picked up from thin air and said, I will give you 2 lakhs. What is the sanctity of the 2 lakhs? I have got nearly 14 years of service to go ahead, my lord.
Yes.
And almost 13 years of service is left over as on the day.
Other side?
Miss K. Aruna, my lord.
Respondent counsel requested for 2 weeks, your lordship, be due to personal inconvenience, your lordship.
Kindly spare a look to the docket, my lord, how many times the respondent counsel had inconvenience. Previously, she was in Andhra Pradesh, consequently, my lord, she was the difficulty. Now, we have a hybrid mode available. Still, there is a difficulty. I don't know. Kindly see the docket, my lord.
In hybrid mode, no?
Pardon, my lord?
But she suddenly told me to ask time, your lordship. She just informed me today, your lordship. Otherwise, I would have informed her before only, your lordship.
Yes, what to do, sir? They are seeking time and matter.
I'll only say, my lord, since your lordship on the last occasion was earlier matters were saying admitted, it was not admitted. Well, now that your lordship had and I had the advantage of hearing your lordship's view on that, may I just make this submission, my lord? Admission of the matter, my lord, does not dispose of the case. So whether technically it is called admitted or not admitted, my lord, practically nothing may happen.
Technically, we will close one step now, sir, because of admission. Why? Because
My lord, the High Court is not so much about the steps, my lord. Your lordship would agree with me. It's not a civil suit where, my lord, your lordship should say that step 1, step 2 will have to follow.
How it looks, 2019 matter is coming under admission caption.
My lord, your lordships, my lord, with rich experience would appreciate, my lord. The reason why notice before admission is normally given is this court feels that this court need not be burdened with this for 10 years to come. So therefore, this court says, yes, as soon as they file a counter, we can be done with it. Unfortunately, that is taken as a leverage for some people, my lord, saying that it will continue repeatedly. Once it is admitted, God knows when it will see the light of the day. But where the case
That is in olden days. Now we have plenty of honorable judges. Reputation is there every time.
That's true. Therefore, my lord, technically admitting it and then listing for final hearing, your lordship with a lot of list, my lord, we are seeing it's practically difficult for your lordship to reach final hearings. Also, some courts. I'm not saying that it will not reach, and I'm not also saying. But after having kept it for so long a period of 4 years, my lord, at this stage, admitting and pushing it further, my lord, would cause prejudice to the citizen at large, number one. And the inconvenience of the court may not be there, my lord, whether it is heading as a final hearing or a notice before admission. It doesn't speak bad about the court because it's a notice before admission. Your lordship will agree with me that it is only with a view to say that we can decide it one way or the other within a short time as soon as the counter comes.
According to you, it won't reflect the court's working system.
It shouldn't, my lord, it shouldn't. Admitted matters are shown in pending matters, my lord. All the matters which are now admitted after 4 years will perhaps may perhaps reflect bad. It took so long for admission and then it takes
Next week or 2 weeks.
then next week or 2 weeks, my lord. I would prefer the first option of next week, my lord.
Okay, post next week.
Okay, sir.
Grateful to your lordship.
Yes. Ravindranath. Admit అయిందా? రవీంద్రనాథ్ గారు. Yes, రవీంద్రనాథ్ గారు.
May please lordship.
Yes,
Mala, this writ was admitted as early as 28th of November 2019. Mala, till now, fifth respondent not filed a counter.
Who is appearing for fifth respondent? Anybody?
Mr. Vidyasagar appears with fifth
Item
respondent.
36, Niranjan Rao. Is C. Niranjan Rao R4?
Yeah, R5, Mr. Vidyasagar appears. Well, it's both of them, they have not filed counter, neither fourth or fifth respondent. But despite the fact 4 years have gone by, and the matter is so simple, Malay, it's only directed against the interlocutor application.
We'll admit the matter post after 4 weeks, sir. What do you say?
Well, it's subject to correction. It's already admitted on 28/11. I mean, subject to correction. That's what I said.
One second, we'll see, sir.
It's already admitted.
The matter listed under the admission caption only, that's what I am asking.
That is. Well, no representation on behalf of the fifth respondent, that is the carelessness.
Notice before admission on 28th of 2019.
Now, with the hope they will file a counter, the learned judge said notice before admission, as Mr. Shiva was also arguing. Matter
Yes,
could
sir.
be disposed of after the. No representation.
Services 4 has to
1 week.
this case.
No, it's a labor matter, it's a GP for labor.
GP for labor is there already.
Yes.
Huh?
4th and 5th are the private parties.
This service matter, no, sir.
That the labor matter, yes, it comes under service matter.
For that only services 4 has to appear.
No, but there, yes, your lordship is perfect. Only thing is there happens maybe only ornamental. Actually, main contesting parties are 4th and 5th respondent.
Who is appearing for 5th respondent?
Mr. Vidyasagar appears for the 5th respondent.
But no, name is not there.
It is not there, but yesterday evening, they said they are going to enter appearance.
What do you say, Mr. Counsel? Yeah, for Vidyasagar. Yes. Item number 36.
Yes.
It may be taken upon.
Thrice that was represented. They said they want to up.
Okalat also is not there.
Well, a notice has been served on the 5th respondent. That's what my
So notice has to serve a 5th respondent?
No, I mean, office has to verify. Office has to verify whether it has been served.
Notice to the 5th respondent post after 4 weeks.
Well, your lordship may say 2 weeks. I mean, notice was already ordered.
No, not at all. According to the court panel, not at all. Not ordered.
Well, 2 weeks
only ordered. Okay.
Your lordship may permit me to take notice also, Malad.
Yes, sir.
Simultaneously.
Take out personal notice to the petition to the 5th respondent. File proof of service. Yes, rule is post 4 weeks.
Very well.
Even, madam, this is. Ready, both of you?
Yes. Matter relating to jurisdiction, you are not. Second respondent issued show cause notice in review show cause notice. And it's not having jurisdiction, and the same has been stayed by, suspended by this honorable court, and the person has been taken on duty. He is on duty, your lordship. Matter has to be decided. Gets the petition.
No, already petition joint duty gala. Then
Matter has to be.
what is it? The issue of the past order under the
Orders have been passed.
yes.
Interim orders. Okay. Interim orders you have passed.
No, I'll ask one question, sir. Present writ petition filed for the against the order where there is no jurisdiction. So this court interim order was suspended. He was reinstated. What else more in this writ petition? That's what my question. You can inflectuous. What's that? If you have any grievance, or you issue fresh notice or fresh orders. So, sir.
Reinstated, but the punishment has been increased. That we have challenged. That punishment increased was suspended. Here punishment was reviewed and removal was
Sir, I'll ask one thing. The present writ petition is filed against your order.
challenging the show cause notice.
Challenging the show cause notice where you don't have the jurisdiction. Correct?
They are saying it is their contention.
No. 1 second. Sir. So, basing on the interim order, you are reinstated him into service. Correct? Correct or not? He is reinstated into service, continuing. Continuing. What else more in this writ petition? I am asking you.
such record as they are presenting before this honorable court. No such record.
Okay, you file that order post after 1 week. Yes, next.
For respondent.
Kindly, this is a resolution matter. Once the appointment is taken place, close.
If they produce the record, that's also.
Yes.
Then in this I have to file counter 38 items.
Okay, post after 2 weeks. What you say, Mr. Nismagav? Post after 2 weeks for counter. Admitted, not even admitted. Admit post after 4 weeks. Newly see. Yes.
One chance. One chance. Please.
ఏందండి బాగోయింది ఇలా ఇప్పుడు పాతకాలం లాగా ఇవాళ అర్జెంట్ అయితే ఇంకా మళ్ళీ వస్తారో అనే భయం లేదు కదా ఆయన వస్తూనే ఉంటాయి కదా మీరే రావడం లేదు చూస్తా ఈ కేసు నెక్స్ట్ వీక్ 4 weeks తర్వాత వస్తారో అది ఉదయశ్రీ 39
declaring the petitioner as fit for the job, but medical report declaring 31/19 I'm not considering the
application.
Compassionate appointment. They have been not.
Counter is filed, huh?
Is not eligible for compassionate appointment.
Okay. Admit rule is say admit post after 4 weeks.
My lordship.
Maybe tomorrow. Nothing doing help.
Okay, pardon my lordship. The petitioner is at verge of his retirement.
Already retired in 2019.
What do you say?
Terminal benefits paid.
Everything is okay. Matter becomes infructuous. You asked. Same thing you said your senior. He is already retired from service.
May I please? Beg to represent Sanjeev Lordship. Lordship may take it up next people.
Okay, post after admission is not at all. Not even admitted.
I have no instruction.
Counter is fine. Good counter.
Council is held up in summer.
Who is appearing other side? Rule is post after 4 weeks.
Next week, we'll have please.
Yes, next. 41.
Obliged.
P. Krishnaya. Okay. Rule is post after 4 weeks.
Your Lordship, I'm representing the petitioner counsel, Mr.
You are admitting, madam.
Your Lordship.
From your counsel, I have argued the matter and admitted. That's all.
Maybe next week, Monday, Your Lordship.
No, admit post after 4 weeks.
No, Your Lordship, please.
No,
Monday.
2018 matter. What is this? Yes, next. 42.
Okay.
May it please, Your Lordship.
Yes, Mohan Krishna.
Actually, in this case, Your Lordship, he is a pensioner, he is a retired. In fact, he joined his duty as a probationary officer in a bank on 18/3/1985. He worked till 1998, and he was.
Appearing other side.
For the respondent, Your Lordship, the 1 week time may be granted.
They are asking 1 week time, Mohan Krishna.
My file is misspelled, Your Lordship.
Last time they were not there, Your Lordship. I leave it to Your Lordship.
Last time there was not there. Last time they are now present. They are asking their file is misplaced.
Yes, Your
Next time what will happen, we don't know.
Next time we'll finish the matter.
ఇది కూడా అడ్మిట్ కాలేదు will admit the matter post after 4 weeks. Any hard and fast urgency is there?
Actually, he is a retired employee. He is dismissed from service, compulsory retirement. He is living on the whims and vibes of his wife. So at least some solace may be granted.
This matter already argued in the court number court.
Yes, Your Lordship.
Closed, argued, but not
already resolved, but released.
Resolved and released, huh?
Yes. No.
You know very well, Your Lordship, the petition counsel.
What do you say, sir? What you will do? Admit post after 4 weeks? Or what do you want to say? Tell me.
Next week it may be heard. That's only what I can.
You ready for post next week, sir?
Like
For hearing, Your Lordship.
So in the date of birth, then almost the time of after 25 years, they admit that my date of birth is 1961. But after 25 years, they say on some medical examination, we decide that your date of birth is 1 year less.
Who is the other side?
The matter is covered by several judgments. One judgment I would hardship.
No, who is the other side? Without other side, I can't do anything. I am helpless. If the other side is there, I will close the itself. Huh?
I'm submitting, but everything is on record.
Others, who is the other side?
RTC.
RTC. Which district who has to appear?
Hyderabad. Market.
Whom Srinivas?
Gaddam
Srinivas. There is Gaddam Srinivas. He will come presently after lunch, small, step by step.
Prospect and this page 9. I need copy and file. Along with page 8. You can see pen number 2. Page 9, para 2. Page 8 is the improved order.
Yes, sir.
9, para number 2. The managing director has accorded permission by reference second subject to reckon the date of birth SL Reddy driver of Market Penny as 2/1960 instead of 21/6/1961 in terms of regulation based on the age assessed by the medical officer at the time of recruitment. Now, the Lordship may see this contrary to the old record. I filed the page slips. The Lordship may see page 13. Page 13, Lordship, 1 to 3rd line in the page slip about in the middle DOP. Lordship,
yes, 61.
61, and this is the Lordship September 2015 in the first line.
When you joined in the service?
I joined when I service.
1991.
91.
1991. When you came to know your date of birth is wrong?
There should be noticed in page 11, 2016.
3/12/2016, they issued notice.
They should notice that we are changing your date of birth. We give explanation. I gave explanation, which is at page 10, page 11. I'll read the explanation. Page 10 is page 10. Just 3 paras. Page 10 minutes. I submit I appointed as statute driver on 19/1991, regulation 17/1994, TSHC. I will issue notice where reference cited, that is 3/2016. That's what I know. To submit my explanation, I further submit I was appointed.
Page you are reading?
Page 10 minutes. Page 10. May I? 2. I further submit I appointed on 19/1991. At the time of appointment, my date of birth is 21/6/1991, and all the records, service record, PKs, nomination, gratuity is the same mentioned today in all the records. I further submit after lapse of 25 years, I was issued with this notice to submit my explanation that the value of my service is improper, injustice, and unreasonable. Therefore,
now how they came to know your date of birth is wrong?
Because
somebody given any complaint?
No complaint.
Then how can they know your date of birth is wrong? Why they issued the notice?
That is the page 11. I read. Page 11.
Yeah.
The managing director has accorded permission to vacate the date of birth of SMLT driver as 6/2/1960 instead of 21/6/1961 in terms of provision of so and so, based on the date of birth declared by you at the time of appointment, which is wrong. Because till 2016, the base.
Generally, if anybody gives complaint, they only give this type
of. What they do, at the time of appointment, they do physical test to see the fitness of the employee. How fit is this a person? Now, after physical assessment, the medical officer says, okay, this person is fit as much as 30 years old. Now, what they will do, mischief, since the doctor said this person is as fit as 30 years old, I will minus the date from the date of appointment and give a date of birth. That is how 1960 has come. This order, Lordship, Justice Munika order.
No, by initial appointment, doctor was tested you.
Every employer.
On that day, what is your age as per the doctor's suggestion?
He said 30 years old and fit. And retired by the 30th.
If it is 38, what will be the date of birth?
1 year I will be losing money.
1 year you are losing.
1 year I am losing. That's my kind of district ruling order. Very much. Number para 2. On the basis of the said above, when the petitioner made a representation request to each service, the second respondent by order will inform the petitioner that he already been attained age of superannuation, therefore should be prepared from service. It is also stated in the said order that on verification of personal records of the petitioner, it was revealed that medical officer Tarnaka assessed the age of the petitioner as 30 years, while medical certificate at the time of initial appointment, therefore his date of birth is 49. Therefore, they say. Now, Lordship has turned the page. Unnumbered para 3.
We'll pass over it. Ask him to attend.
Yes.
Pass over. Ask him to attend. Yes. Item? Yeah, please. Yeah, please, Lord. Yes, sir. This court is very interesting to close this case.
I will pass on.
Tuesday you want?
Tuesday one.
Tuesday. What's up? Yes. అందుకనే మీలాంటి యంగ్స్టర్స్ ఇలాంటి యంగ్స్టర్స్ ఎనర్జీ వేస్ట్ కావద్దని మొదలే అడుగుతాను. ఆవేశంగా అరుగు చేస్తారు. అదర్ సైడ్ లేదు. నేను ఏదో క్లోజ్ చేద్దాం లైక్ కేసు నేను అనుకుంటే సరికి ఓకే ట్యూస్డే విల్ సీ. నెక్స్ట్ విచ్ మ్యాటర్ మేడం? 44. రెడీ? ఓకే పోస్ట్ నెక్స్ట్ వీక్. అడ్మిటెడా? నాట్ ఈవెన్ అడ్మిటెడా? అడ్మిటెడ్. ఓకే నెక్స్ట్ వీక్. You are representing Mr. Gatan Gopal or Srinivas? Okay. Yes.
For petitioner in the WP.
What, madam? Delay petition is pending, huh?
In CMA. CMA.
How the CMA is listed this court?
Both the matter is connected as
the partial order. Delay, we will condone the delay. What is any objection?
There's no objection.
Okay, so we condone the delay. Post after 1 week.
For both the matters.
Lakshmanachari.
I have heard the respondent in this matter, Miller.
You are for respondent, sir?
Yes, Miller.
Ready?
I filed the implead petition, Miller.
Implead petition?
Implead petition.
Is it the implead copy?
Yes, Miller.
No, here the petitioner counsel is here, he not received the implead petition copy. Serve him, I will post the matter next week.
Okay, Miller. I will serve you.
The post next week. What's your good name?
Kamlakar Rao.
So serve the copy to the petitioner counsel, sir.
Yes, Miller. I will serve it.
You know his name. Who is petitioner counsel?
Yes, Miller. Lakshmanachari.
Yes, you serve the copy to him.
Yeah, I will serve him.
Next week, okay.
Okay. For 10 days may be get.
Okay, post after 10 days.
Which
Next 48. Maharani.
May I please, Your Lordship?
Yes, madam. Ready, both of you?
My Lord, in this, my Lord, the present witness filed, my Lord, challenging the implead proceedings issued by the first.
Earlier also not by this court or
Cancelling.
first time it is coming.
Earlier also,
Why it was adjourned today?
other side was not, that's the reason it's been on journey.
They are not writing any. This one, why they are adjourned simply list on. No, our persons are not writing. Why?
Before this court, it's coming first time. Before this court, it's coming first time.
This is fourth time, madam, this court. 4/8/2023, 18/8/2023, 3/11/2018. Yes.
I'm ready with the case. My lord,
Also ready, na?
Yes.
What's the matter about?
my lord, the present it is my file, my lord, challenging provision cancellation of provision selections of the petitioner to the post of constable, my lordship. My lord, the petitioner has participated in the selection
Elections are
process.
already over, na?
Selection is already over. He has participated in the selection process and he has been selected, my lord. His selection was cancelled on the ground that he has suppressed the facts and the criminal cases were initiated against him. My lord, there is no suppression of fact. Your lordship may kindly take page 17, my lord, 17 of the material paper. Here, my lord.
For suppression of fact, there is judgment is there.
Yes, there is covered judgment that I have filed along with my writ petition. This is a covered matter.
Follow the judgment.
We have lordships of Justice Abhinan Kumar Shavali also, lordship. This judgment.
No, you follow the judgment, that's what I am saying.
Lordships, in this, actually the petition was dismissed, your lordship, basing on the fact that
Suppression of facts.
there also suppressed the facts, and in this judgment it is clearly stated that suppression of fact dissent. I may pass.
One submission, my lord. Here, my submission is there is no suppression of fact. He has stated that he was involved in the criminal case. Prior to going to the judgment, my lordship, your lordship may kindly take page 17.
Yes, yes.
Your lordship may kindly take page 17, my lord.
You filed the counter, madam?
Yes, your lordship, we have filed.
Yes.
Here, my lord, page 17.
Page
Your
17.
lordship goes whether you were involved in any criminal cases. At the last, my lord.
Page 17.
Yes, my lordship, page 17. Were you involved in any criminal cases at any time? Here, my lord, were you involved in more than one criminal cases? He said yes. He has stated so.
Where is which column, madam?
This, my lord, at the end of the page, my lord, from bottom it's 10th line, my lordships. Were you involved in more than one criminal
Were
case?
you involved in more than one criminal case?
He said yes.
Yes.
There is no suppression of facts, my lordship.
Yes, sir. Yes, madam.
There is no suppression of fact.
In the details column, your lordships, if your lordships will actually see the same page.
No, madam, specifically there, column is there, answer also is there.
Yes,
Yes.
but
There is a question of suppression again.
but details are not provided by him.
But
First,
that is not the answer. Suppression is not the answer.
lordships, here he has said total number of cases involved. He said one, your lordship.
No, what is your question here? Where you involved in more than one criminal case. It
Yes.
may 2, it may 20.
20.
For that, what is his answer? If he says no, that is suppression.
Next,
He said yes.
next point, your lordship,
Total number of criminal cases involved.
one.
More than one, because there was only one option itself, my lord.
No.
My lord, as your lordship
Your
has
answer is itself discriminating two things.
more than one case, means if you could have
No,
said
answer for first question, were you involved in more than one criminal case? You said yes.
yes.
For that answer, what will be the second question answer? Total number of criminal cases involved, only one. If it is one, where is the question of saying yes for first question?
My lord, my submission to that question is, my lord, there was only one option of one. That's the reason he has pressed what. That's what my client has stated me. But in the first question itself, he could have said no. That would
What's
be
the question?
whether you were involved in more than one
Detailed
case.
question is there. Were you involved in more than one criminal case?
Yes, I said yes. I said yes.
Next
That
question.
itself is not suppression, as your lordship has rightly pointed out it. If I could have said no, that was different thing. I said I am involved in more than one cases. If it
You
could
said
be
yes. Second answer will not be not like that. That is suppression. You have said only one. You have to write 2 or 20 or 200.
If it is more than one, my lord, see, my lord, if it is,
Madam, I'm not.
one submission, my lord, if it is more than one, I said yes. More than one. If it could have been 20, then that would be different. He has written
More
2.
than one means what is this, madam? Answer. More than one means you may have 2 cases, you may have 200 or you may have 20.
But here, my lord,
10% you write, only one case is pending. Nothing but suppression. Or by mistake you suppress.
no, my lord.
Mistake you suppress. Instead of
Yeah, by mistake it may be, my lord. But he was involved in 2 cases, which was acquitted, my lordship. Both the cases were acquitted. I filed the judgment copies of both.
judgment.
That is not in question, Your Lordship, whether it is he is acquitted or convicted, Your Lordship. The fact is that he has suppressed.
Even otherwise, also
Question
for
is-
suppression, there is a judgment is there, madam.
Yes,
Mana Ajay, what is it? Avatar Singh case.
That's what I'm relying
All
upon.
that Avatar Singh case.
We have also extracted the portion in our counter, Your Lordship, after Singh's judgment at page number 5.
The number?
5.
Your counter only. This one?
Counter, Your Lordship. Point number 17, Your Lordship.
1 second, madam. Yes.
I submitted that simply the division bench of this Honorable High Court, by orders dated so-and-so in writ appeal so-and-so filed by the board against the judgment dated so-and-so, allowed the writ appeals observing that Rule 3, Clause D of the AP SCT rules prescribe certain disqualification for appointment, and in the light of the aforesaid rules, the observations in Avatar Singh judgment of Apex Court cannot be applied blindly without the said rules being set aside upon inappropriate challenge being made to them.
I think there are 2 Avatar Singh cases are there. I
No.
think it is not the proper.
Well, at page 22 of my petition with relating to the suppression of act in Avatar, page 22, my lordship.
Avatar Singh case.
Yes, my lord, page 22, my lordships.
Page?
Page 22 of the, page 56, my lordship, page 56 is the judgment which I am relying, my lord, in which the extract of Avatar Singh has been given at para 21, page 56, para 21, my lordships. Here, the decisions cited above are in tune of decisions in Avatar Singh's case. Therefore, in the light of the observations set out by the Supreme Court in Avatar Singh's case, 1 Supra, what is relevant is what is suppressed, that matter, not every technical or tribal cases. The offences charged against the petitioners being not such a serious offence like murder, dacoity or rape. A lenient view deserves to be taken in the matter.
Yes.
In the writ petition, my lord, which I am relying upon, this is a covered judgment of this honorable court, my lord, given by Justice, Honorable Justice Rajshekar Reddy Garu, my lordship. Here, the suppression of facts as well as involvement in the criminal cases relating to the theft with the petitioner is involved. The writ petitions has been allowed setting aside the impugned proceedings, my lordship. So I am relying on this judgment, my lord, because this is squarely covered to my judgment, to my case.
So if I allow the writ petition, what will happen? Already recruitment is over, no? Selections are over.
Yes, my lordships.
Once selections are over, what can you?
My lord, there are many posts in the present recruitment also, my lordship.
Your senior has to come. We'll ask, discuss with him. Or you get the instructions.
Next week.
It's a fit case to consider under the Avatar Singh case.
But Your Lordship, subsequent to that, we have judgments of our Honorable High Court also, Your Lordship. As with the one which I have passed on, Your Lordship. One which I have passed on just now.
This one.
Lordships, may I kindly see last paragraph, Lord. Having considered the rival submissions made by the learned counsel on either side, this court is of the view that the tribunal was not justified in allowing the OA, as admittedly the first respondent has suppressed about the criminal record and his conviction. Had the first respondent disclosed his criminal record, then the case of first respondent could have been considered under GOMS number so and so. Therefore, suppression of fact, this entitles the first respondent for being considered for appointment as police constable. Since the police department is highly disciplined force and paramount importance in the society, if the persons like respondents are appointed, it may lead to turbulent situation.
Yes.
I have another judgment also, Lordship, in this regard.
You have the copy with you, madam?
Just now she has said, but my lordship, In this,
it will post the matter after.
I have judgment shall pass that only.
one submission, my lord. The present writ which I am relying, my lord, these are the batch of the writs which has been filed and allowed. Those are concerned to this present recruitment only. All were considered and they have given the appointments also, my lord. Because this case was pending, the petitioner has been got a lot of damage, my lordships. He is aged bar also.
And second, if it is age bar, what will the?
To my lordship to go for further recruitment, my lordship. Your lordship may kindly consider, my lord. He is not eligible for other recruitments because.
No, how they will consider there should be some program will be then. They already elections are entire selections over.
Yes, my lordships.
Then
they can create a numerous
and
they can give because there are many posts. There are many posts, my lordships, in the constable district.
Next week, I will say because the suppression of facts, Avtar Singh case can follow. And you clear whatever the two cases, only two cases are pending.
Yes, my lordship, I filed the judgment. Also, they have been acquittal, my lord. Both are acquittal, my lord. For orders, my lordships. Under the caption of orders, because, my lord, again it will go, my lord.
No, how it will go? Get instruction, madam. This court is you are discuss with your senior. This court wants to follow the Avtar Singh case. If it is suppression of facts is there, one answer given correctly, where more than one case he said yes. And by mistake he written one. Lapse of understanding. Lack of understanding. So this case can treat as suppression of case, criminal cases. So can we consider the case under the Avtar Singh or not? You get instruction. Next week we'll.
Yes.
Next. 49, yes, Surendra Reddy. Yes, sir.
Petitioner is working, my lord, as
counter is filed, sir.
Counter is filed, my lord. But my lord, the case is a simple case, my lord. The petitioner was on medical leave, my lord. After giving joining reports, was not admitted. Finally, my lord, she was admitted on duties, my lord, 27/8/2018. After admitting into duties, my lord, she made a representation to treat the period of out of service as on duty.
On duty,
On duty or my lord, as per rules, my lord, once an employee is admitted into duties, my lord, they have to treat that period as that is whatever the discretion lies with the authorities, my lord. As per fundamental rules, they have to treat some. In those circumstances, she filed a representation. They have to take it. They have to pass orders on the representation. They are going to be treated on duty or otherwise.
You are not representation.
Yes, at the time of admission, the honorable court directed to pass orders on the representation.
Any dates? Time is fixed for that.
Time, my lord.
Counters are not filed.
Counter is filed. Counter is filed, my lord. But my lord, in the counter, they are stating that they are going to be take disciplinary action for the another absence.
Interim direction is there.
Yes,
sir. Your representation.
Yes, my lord. I am only seeking let them take decision whatever they want. Positive or negative.
Any time is fixed for that. Student photos. Within 6 weeks, they have to consider representation. If they have not considered, what will be the next course of action? If they are not considered, they are disobeyed the order of this court. What will be the next course of action?
That is why, my lord, my request is let them the same order may make as a final order. Let them take a decision, my lord. My lord, she is working under the control of the respondent. She is afraid of filing contempt.
What is it, sir?
Seek instruction on this.
Last week also, my lord, this short time, my lord, you last see the docket order last week.
Lordship, it may take up on Tuesday, Lordship will confirm it.
Last week, other assistant computers came, my lord, Mukram Khan. He short time for getting instructions. It's an in-course order.
Okay, on Tuesday, post on Tuesday. At the request of respondent, you write that entire word.
Right.
Hanuman Naik.
I'm representing Umadevi, my lord. We already filed counter, my lord.
Which matter, sir?
Item 51, my lord. Hanuman Naik.
Ready, sir?
No, sir. 1 week time.
He's asking
After
only-
2 weeks, my lord.
Okay, post after 2 weeks. Next.
Hey, please, your lordship. Appearing for the petitioner counsel in this matter, my lord. In this matter, we'll have to file an implead petitioner for the respondent number 4, my
after
lordship.
2 weeks.
Obliged.
Narasimha Gaud.
The issue of choice. I can explanation. Even I will take up the file. I won't. Inquiry also. I gave this 4-3. They have conducted inquiry on 4-3 itself. On that particular day. No notice. And they do not issue any show cause notice. They directly go ahead with issuing the page 3.
Ready, sir?
Yes.
Yes.
15 page.
Page 15, sir.
Yes. My content convention, but they have filed comments with the agency. Lordship page 15. Lordship see reference office charge sheet so and so dated 1/3. Explanation charge 4/3/2014. Lordship underline those 2 dates. Then I will take the order. After giving careful consideration, the explanation submitted by the charge sheet and the stands proved for which the penalty of deferment of is proper and I therefore hereby ordered that the army will next falls before for 1 year. So admittedly, even after the order, according to me, no inquiry, no show cause. Lordship kindly appreciate. That reference will not be seen, no inquiry, no show cause. Then I filed an appeal. They dismissed my appeal stating the time part. There was only a delay of 8 days. They did not condone. 8 days they say, and they file a counter. And first that's the inquiry page
number.
There is no page number. It should be page number 5. Okay, page number 5. Lordship kindly highlight the date 4/2014 on the top.
Yes, 4/3/2014.
Lordship, the previous impugn order, I showed the charge sheet explanation that they gave on 4/3/2014, which means whenever I went, they made me sit, they made me conduct inquiry, and immediately they pass orders. Even assuming that this is an inquiry, no notice, nothing, they made me check, no opportunity of what document they are going to produce. That opportunity has been denied. It is an admitted fact for a mere reason that on the day when I went and gave explanation, on the very same day they can conduct inquiry. And on the affidavit I stated even inquiry not conducted. I did not even realize till I saw the counter that the inquiry was in fact conducted. And my lordship, they do not give me a show cause notice. Now this principle has been settled in my lordship knows Kulwan Singh Gill case. Major punishment inquiry show cause notice is a must. And to that extent, my lords, I have one small judgment.
What is it, sir?
So now file my counter. Counter is part of record. Lordship may kindly see.
Counter is part of record, correct, but without conducting any inquiry, without issuing any show cause notice, how will you take a decision?
No,
Final
admittedly.
decision. Is it the fact or not?
I have to. If that is not required,
No.
I will produce a judgment to that effect.
Not good, sir. Page 15, under the reference, this office charge sheet so and so, you're explaining so and so. Without issuing any show cause notice, straight away we can issue charge sheet. If I am not wrong, Mr. Counsel.
Lordship may kindly say no. Admittedly, they failed to approach the labor court. straight away file the writ petition. That has to be analyzed before the appropriate forum.
They have to go to labor court now,
Labor court, they have to go.
after long this period.
No, in fact, order is of 2016, review orders. They have filed writ petition after 3 years.
After 3 years they filed.
2016 order, they have filed writ petition in 2019 without going to labor court.
Regards, sir, we'll see.
Publish.
When do you want?
2 weeks.
Okay, post up to 2 weeks.
Publish.
Yes, Ramesh Babu garu. Samson Babu.
Please, Your
Both sides are.
May please. Lord, this writ petition is filed questioning the orders of the appellate authority. The matter arises under the Payment of Gratuity Act. The petitioner was appointed, my lord, in these as an artisan grade 3. My lord, he was dismissed from service. His appointment was dated 7/10/1979. He was dismissed from service on 14/12/2013.
When he was appointed?
My lord, on 7/10/1979.
2017?
October, 7th October 1979.
1979.
Yes, ma'am. As an artisan.
Yes. Yes.
Grade 4, and he was put in the estate department of township administration of the BHEL.
Retired from service also.
He was dismissed from service on the charges.
But
Charges is.
This number showing the date of retirement 2024.
Yes, that is exactly what I am saying. They have calculated 2 years more and then awarded the gratuity. But since he was dismissed from service on the charges of moral turpitude.
When he dismissed from service?
He was dismissed from service on 14/12/2013.
14/12/2013.
Yes, ma'am. The order is
on what ground?
Page 63. Lord, on the charges of moral turpitude, my lord, causing pecuniary loss to the institution or the organization by colluding with one Mr. Hassan Hussain Khan and grabbed the land of BHEL illegally from its possession. That was the charge that was leveled against him. It was held to be proved in the inquiry. Consequently, he was dismissed from service. My lord will find it at page 63.
Yes.
14/12/2013.
Yes, yes.
Charge 1, my lords have seen, my lord, along with so and so. Presently, senior manager so and so had colluded and conspired with one Mr. Hassan Hussain Khan and others to grab BHEL lands illegally from the possession.
Yes.
Further, it is on the record that Sri so and so, while discharging their official duties, were involved in conducting a survey of BHEL lands against the interests of BHEL and without official sanction of the competent authority. Charge 3 was participated in the survey proceedings as witness without any sanction or authority. Signed the Panchanama knowing fully well that the possession of the land rests with the BHEL. Charge 4, in spite of being a BHEL employee, Sri J.R.S. Sharma has represented Sri so and so as his authorized representative in the ORC proceedings before the RDO Sangha Reddy in proceedings number so and helped him to obtain ORC proceedings in his favor and also file a suit OS 59 of 2010 against the BHEL, claiming BHEL land in survey number so and so. Charge number 5. He has also assisted Sri so and so in filing application before the Deputy Collector Land Acquisition by giving his address, water number 730 ABHL Township, RC Puram, Hyderabad, in the application filed for obtaining the details of the land acquired by for BHL. Charge 6. So and so has dishonestly manipulated the available records with BHL by misusing his official position and help the third parties, rival claimants, to claim BHL land and in the process he made undue pecuniary gains by registering a part of BHL land in the name of his wife, Srimati so and so, from Ahsan Hussain Khan.
Yes.
These are the charges which were held to be proved. And then
Proved or not proved?
all the charges are proved. He has participated in the inquiry. So the operative portion of the dismissal order, page 65, bottom middle, the above acts of so and so which are detrimental to the interests of BHL are grave in nature and constitute major misconduct under subclass D so and so of the Act. And standing order 20 of the BHL considering so and so. The undersigned as a disciplinary authority therefore order that the penalty of dismissal from service is imposed on so and so under the provisions of the standing orders of the BHL. The order of dismissal from service shall come into force with immediate effect.
Appeal is filed, huh?
No, Lord. He carried the matter to the labor court in an industrial dispute. He has filed ID 54 of 2015 in the Central Government Industrial Tribunal at Hyderabad. Lord, the application which is filed before the labor court is at page 78.
Appeal provision is there, sir. Appeal provision is there in the same.
The appeal provision will not. He has raised an ID, Lord, at page 78, Central Government Industrial Tribunal from Labor Court at Hyderabad. ID 54 of 2006.
What happened to ID?
It is still pending.
It is still pending, huh?
Still pending.
Why it is pending? From 2015 onwards?
Yes.
What is this?
Therefore, whether he has indulged in moral turpitude or the orders passed dismissing his premise are yet to be adjudicated by the competent labor court.
Then why the labor court is not closing this case for the last several years? 2015.
Not the consideration now that the impugned order assigned brought in the requisition is the controlling authority under the Payment of Gratuity Act went wrong. And in the appeal also confirming the controlling authority by the applied also went wrong. Therefore, questioning both the two orders by issuance of writ of certiorari, he filed it. Therefore, now my respectful submission is that whether termination is a misconduct and whether the termination is justified or not, why it is pending is not criteria. What my lord, they have permitted the gratuity by a separate order, which available at 41.
Page 41.
Page 41.
Yes. Millard, I complete it in a moment, Millard, then he can proceed with it. Millard, since the charges are under after dismissal are under moral turpitude, Millard, Payment of Gratuity Act under section 461B would read as follows. At page 7, I have extracted the provision of law.
Yes.
Notwithstanding anything contained in subsection 1, the gratuity payable to an employee may wholly or partly be forfeited if the services of such employee has been terminated for his riotous or disorderly conduct or any other act of violence on his part, or if the services of such employee have been terminated for any act which constitute an offense involving moral turpitude, provided that such offense is committed by his in the course of his employment. On this basis, my lord, the orders were passed withholding his gratuity.
Gratuity.
Yes. Challenging that, he has gone to the controlling authority under the Act. And the controlling authority, my lord, passed the orders on 27th May 2016. This begins at page 24.
Four.
24 minutes, 24. And the order is at page 30. Therefore, in legal position and also factual matrix referred above, hereby order the management to direct to pay an amount of gratuity to the applicant Sri so and so, enclosed in the order within 30 days from the date of receipt of this order, calculating of the gratuity payable to the applicant is as follows. Say date of appointment 7/10/1979 and date of retirement 24/8/2015. This is totally incorrect. He was dismissed from service. He has not retired from service. And he has challenged the dismissal order in a labor court. And the controlling authority holds that he has retired from service on 24/8/2015, and the total period of service it calculates as 35 years of 10 months and 7 days. And amount of gratuity to be paid is 10 lakh. As against this, my lord, I have approached the appellate authority under the Payment of the Gratuity Act. My lord should find it at page 13.
31.
13, my lord, 13. And the orders passed by the appellate authority are from here, page 21, last but one pair. Hence, in view of the above paras, I hereby confirm, modify the order of the controlling authority under PGI, partially regarding the payment of the gratuity amount along with the simple interest of 10% on the principal amount of gratuity. Total gratuity amount of rupees 9,39,204 plus interest from 15/12/2013 to till the date of deposit of the gratuity, that is 6/12/2016, amounting to rupees 2,79,703. Should be paid to the ex-employee. I hereby direct the controlling authority to disburse the deposit amount of gratuity of rupees 10 lakhs within 1 month of the 1 month to the ex-employee, and hereby direct the employer to pay the balance amount of rupees 2,18,907 within 1. So he has increased the amount from 10 lakhs to 12,18,907. In my appeal,
You are not discussed in this appeal with regard to the retirement or this issue.
he has not written.
No, you filed.
Yes, that was the main reason, my lord.
You have discussed anything with regard to that?
Yes.
That statement, retirement.
Yes. They only dealt with, they went on to decide whether the charges level by.
What is the relief you are seeking from this court now?
Has to set aside these both the orders. In fact, 10,000 he has already received.
10,000 already received.
Received.
10 lakhs
already received. And the balance amount he is seeking is 2,18,000. Which is, calculated and comes under the caption of interest payable. 10%.
Interest portion.
Interest.
If you are ready to pay the remaining amount with interest, you are okay. Nothing to do worry about the order. Huh?
No. My friend is relying upon a judgment of the Supreme Court. Now let's kindly look at that judgment, because that has got a bearing on the present case.
But my question raised by this now, you are not discussing what you are showing the mistake there with regard to retirement. You are not discussing anything.
No, my contention is so far I can withhold the entire pension under 1641B. Because it says if the employee is dismissed from service on the charges of moral turpitude, a discretion is given to the management to withhold it. My lords have seen that legal proposition. Shall I read it again for my lords?
Yes.
Page 7, last bottom.
Page 7.
It is humbly submitted that section 461B reads as follows. This is payment of gratuity. Notwithstanding anything contained in subsection 1, the gratuity payable to an employee may be wholly or partly be forfeited if the services of such employee has been terminated for his riotous or disorderly conduct or any other act of violence on his part, or If the services of such employee have been terminated for any act which constitutes an offence involving moral turpitude, provided that such offence is committed by him in the course of his employment. So my case is all the charges, 6 charges leveled against him are proved in the inquiry. That 6 acres of land was registered on the name of his wife by the person to whom the land was taken away from the BHA. He has assisted him, and even he has given his own address for the communication with the revenue authorities. Therefore, invoking the provisions of this 461B clause 2, if the services of such employee have been terminated for any act which constitutes an offence and involving the moral turpitude, provided that offence is committed by him in the course of his employment. Therefore, I am entitled to. I need not pay any amount to him, my lord. I can for the amount which is payable to him under gratuity is forfeited. Now he relies upon a judgment of the Union Bank of India and others versus C.G. Ajay Babu and another. Lord, this is 2018-9 SCC.
I have some copies for me.
He has filed along with a memo for this.
Memo. Counter is there, memo, yes, memo. Yes.
This is the case of a bank employee who was also dismissed under the charges of moral turpitude.
Memo, there is no citation, only just
Judgment is in. Yeah.
What up? Second memo. All the memos only extraction. Yes. Yes, sir.
Well, this is a case where an employee of a bank was dismissed from service, but not on the ground of moral turpitude, but where there was no pecuniary loss that has occurred to the bank. Therefore, what the Honorable Supreme Court has held is that since no pecuniary loss has occurred to the bank could not have withheld the gratuity payable to him. Under 461B clause 2, it cannot be forfeited. That was the ruling of the Honorable Supreme Court. Lord, footnote I will read. Held, it is not automatic on dismissal from service, but it is subject to subsections 5, 6, 4. Further held that non-obstinate clause contained in subsection 5 of section 4 has overriding effect over all other subsections. Notwithstanding anything contained in section 4, employee is entitled to receive better terms of gratuity under any award or agreement or contract with the employer. Furthermore, scope of subsection 5 of section 4 is not restricted only to the quantum of gratuity under the award or agreement or contract. Held, the subsection 5 of section 4 provides for better terms of gratuity under any award or agreement or contract, which means all terms of contract. Choice is between the award of or agreement or contract and statute, but not partially or otherwise. Besides, in terms of the bipartite settlement dated 19/8/1966, forfeiture of gratuity was permissible only in case of misconduct leading to dismissal had caused financial loss to the bank, and only then, that extent, the gratuity can be forfeited. But in the instant case, misconduct of the respondent employee had caused no financial loss to the bank, and therefore forfeiture of gratuity by taking recourse to subsection 6 of section 4 is impermissible. He is relying upon this judgment. Lord, I will clarify the 2 points which differ from the instant case. Lord, there is a bipartite agreement which governs between.
Where is that agreement?
No, bipartite agreement, not bank agreement. That is between bank employees and the so and so. Where it is stated that a misconduct leading to the dismissal caused to financial loss to the bank, only to that, in such an event, the gratuity can be forfeited. So far as I am concerned, my lord, there is no such agreement between me and the ex-employee to whom the gratuity is directed to be paid. On the other hand, my lord, my standing orders would show that the entire amount of gratuity can be forfeited if the charges of termination are under the moral turpitude. Now, whether the moral turpitude allegation which I have leveled against him is right or wrong is yet to be proved by the labor court.
And why labor court is not closing, sir, this case?
My lord, labor court. Lord, my submission is, my lord, today, what the reputation is concerned about, my lord.
It's only two proceedings.
Two proceedings, which is based on, my lord, the forfeiture of the gratuity. We have nothing to do with the charge termination, whether he is entitled for factual or anything.
Yes.
So therefore, you last for a minute. Samson. Page 41, you last me kindly see. The material papers filed along with the report.
41. Yes.
This is the, my lord, the office order dated 30/12/2015. This you last may make a note of it. My submission is 30/12/2015. Is the, my lord, order of the this. Then, my lord, you last may kindly see, my lord, the last but one para, my lord, at page 42. Whereas Mr. So-and-so has contended that the gratuity is his contribution of salary and the local management do not have any authority nor there is any enabling provision of law to forfeit gratuity. Gratuity is a part of the salary that is receivable by an employee from his or her employer in gratitude for the services offered by the employee in the company. Next, you last me. Under clause 4(6)(b)(2), II, the payment of gratuity 1972. The gratuity payable to an employee may be wholly or partly forfeited if the services of such employee have been terminated for any act which constitute an offence of moral turpitude, provided such offence is committed by him in the course of employment. The provisions under the payment of gratuity 1972 enable the employer to forfeit the gratuity just and so and so. In the undersigned, after careful consideration, careful examination of the facts and circumstances on record, and the reply dated so and so to so called notice submitted by so and so, has come to the conclusion that the acts committed by Mr. So and so amount to offences involving moral turpitude. This you last may kindly make it note of it. So therefore, the entire order of forfeiture of my gratuity under the Payment of Gratuity Act is clearly they admits under clause 4(6)(b) subclause 2 II, which also they said that why they have forfeited is under this clause. Then, my lord, my submission is to invoke this clause. The employer have no jurisdiction. Why? My lord, the Supreme Court said, my lord, the offence of moral turpitude is traceable to the criminal law. There should be an offence, there should be a complaint, there should be an adjudication by the criminal court. That what the Supreme Court says. You last may kindly see now, my lord, 2018 9 Supreme Court. Case 529. Union of India was yes. Head note C, my lord. You yes. Head note C. Labor laws, payment of gratuity. Forfeiture of gratuity is for misconduct. Constitute offence involving of competent jurisdiction. Offences involving committed on facts and respondent was not done, which according to appellate bank was hence there was no justification. Beside requirement of statute is not proof of misconduct or act, but act constituting offence involving moral and said offences duly established. Further, to be offensive act should be punishable under the law, which is absolutely within the realm of the criminal law, and is not the bank to decide whether offence has been committed or not. So therefore, my lord, clearly, the jurisdiction alert, they have no power or authority unless I can understand, my lord, there is a charge, moral turpitude against me. Then what they have to do is, my lord, they have to go before the magistrate under 199 complaint or lodge a complaint before those. Then, my lord, the prosecuting authority, whosoever, my lord, then a charge sheet to be framed, and the criminal court, my lord, is the competent jurisdiction to decide, because it is a criminal affair. So then, my lord, this was discussed, my lord, in para 17. He said, no, there's no effective nothing. Para 17.
One second, sir, 1 second. There are 17.
17. One second.
Though the learned counsel.
Yes, those conduct of the respondent. You are afraid. The contention cannot be not the conduct of the person that is required for particular, but the conduct or the act should be made punishable under law. That is absolutely in the regime of criminal law. It is not for the bank to decide whether an offence has been committed. It is for the court, apart from the disciplinary procedure. Bank has not checked the criminal law in motion, either by registering FIR or by filing the criminal complaint, so as to establish misconduct leading to it happens involving moral turpitude. Under the subclass 6B Act, forfeiture of gratuity permissible only if the involving moral turpitude, conviction accordingly by the court of competition. What more, my friend?
Yes.
This is the law.
What is it, sir? Sanctionary in this regard?
So far as DHL in instant case, no complaint law. No criminal court jurisdiction was involved.
Yes. What is it? If it is
No FIR is registered against him or any other person.
so how the
In as much since my lord, the revenue against the orders of the revenue authorities, they have approached this Honorable High Court. And there was a stay granted by this Honorable High Court in so far as the land is concerned. But there's offense.
that is out of person.
Yes.
The issuing the proceedings
Yes.
against the jurisdiction area, against the rules and regulations, how far it is maintainable?
Yes. So far as this moral turpitude, labor court is now dealing with it.
But the issue is only for this now. And
Yes.
it is there.
Separate act is there, separate authority constitute.
Yes.
Labor court, if I file application along with 2 year 2 payment of gratuity also, it will be without jurisdiction, it has to be dismissed.
Yes, sir.
No, BHL has not registered any FIR. They did not take any complaint
Yes, yes.
under the criminal. That is. But what about this interest part? The original controlling authority, what it says is the date service computation, Millard, for the calculation. Lords, may kindly see that page 30.
Page
30. Admittedly, he was dismissed from service, Millard. Yeah. But they say that he was retired from service and had 2 years of service.
That is not the point for this consideration in this entire case. Is it correct or not?
No, the calculation part is also erroneous. Lord, he was dismissed from service on 14/12/2013, which has challenged it in the labor court.
Disregard.
Principle, my lord, they have no jurisdiction to once that go. Calculation, my lord, is proper.
Now we will come to calculation. One thing is
What
clear, they don't have any jurisdiction to forfeiting of your gratuity.
Yes, then my lord, what is the actual gratuity to be paid? You ask me kindly see, my lord, the counter which I have filed in the petition. Counter filed by respondent number 3 employees.
All memos are there, sir. Counter.
No, counter is there.
Oh, yes, counter.
Page 3 of the counter.
Yes.
You like my kindly see the date is 15/12/2015.
Application of respond number 3, claiming payment of gratuity.
So, my lord, the authority under the Payment of Gratuity Act is the controlling authority. I filed application on 15/12/2015. Then, my lord, 30/12/2015, when my lord, the controlling authority being the court or the statutory authority under the Act, application is filed for adjudication. Not 30/12/2015, after that, my lord, they permitted the grant. It is not that before. I filed, my lord, since 2 years have lapsed from the date of termination. Because the Gratuity Act says, my lord, superannuation termination. So my termination in 2014. Up to 2015, they did not pay gratuity. After 2 years, my lord, I filed because the gratuity to be paid within 30 days.
30 days.
So that is the reason, my lord, the Act provides, my lord, within 30 days, if it is not paid, it involves, my lord, that interest at 10%. Government notified us. So therefore, my lord, while the adjudication of my application before the controlling authority is pending, on 30/12/2015, my lord, they have permitted, this is another, my lord, lacuna in addition to the, my lord, the principle. Then you last my kindly see.
But how can you they take the amount, excess amount to 2 years?
They say, my lord, it is an excess amount. You last my kindly see.
If, as you said, if there is any delay, they are going to pay interest portion. So you have no right to collect the excess amount for excess service.
No, for that extent, my lord, the order you last may kindly see. Termination order. Termination order.
Dismissal order, termination order. 63. 63. Provide move.
63.
Yes.
Yes, orders of the disciplinary authority.
63. My lord, then 66, my lord, you last me time.
Yes.
66, my lord, third, my lord, is the order of dismissal from service shall come into force with immediate effect. So that means, my lord, it's traceable to 14/12/2013. So from 14/12/2013, my lord, I am entitled to grant.
From 14/12/2013.
13, I am entitled for grant. Within 1 month, I have to be paid. Then, my lord, the controlling appellate authorities, my lord, order, because the controlling authority said straight away I am entitled for 10 lakh, whereas appellate authority, my lord, has modified the order, which you lot may get it, my lord, page 13. The last page, my lord, at page 22. 13. Yes. Page 22. The calculation, my lord, given by the appellate authority is, my lord, a brief calculation of gratuity amount and interest is here under. Last drawn salary is 47,881. My lord, then, my lord, number of years service, including the superannuation period, is 34 years, 2 months, 9 this. So this, my lord, can be limited up to, my lord, that termination order. Because the termination order tomorrow set aside, I am entitled for the up to retirement. Because I am entitled for future retirement, so they have wrongfully terminated once termination goes. I am entitled for this. So therefore, my request is, my lord, that what my friend rightly pointed out, that I am entitled for, my lord, up to termination.
Up to termination.
That is, my lord, the termination is, my lord, the 2030.
30.
Then, my lord, then thereafter, my lord, then it says 34 years. So what is the actual years, my lord, we have to take in instead of 34 years, from the date of, my lord, joining to the date of termination. So what is the actual years? Then, my lord, that is to be applied by, my lord, 47,881 per month into 15 days into number of years. Comes to, my lord, here, my lord, 9,39,204. The figure will be deferred, my lord, that once calculation is there. Then, my lord, the interest, my lord, from 2013, because the termination within 30 days, I am entitled to get the payment. Yes, correct. Gratuity as per the provisions of the Act. Into, my lord, up to, my lord, 6/12/2013, that is 2 years, 357 days come to this month. Here, my lord, we have to calculate is up to today. Because no up to today. So that 10 lakhs deposit date to be taken, my lord, then interest to be calculated. Then, my lord, add the, my lord, principal gratuity payable, that number of years into also period, plus, my lord, up to the 10 lakhs is paid. Then principal amount and interest add together minus 10 lakhs, whatever that remainder comes, But I'm entitled to get even till date, because 2017, my lord, the applied authority's order is 2,18,907. I'm entitled to get as on 20th July 2017.
No, for my understanding.
Yes.
The here entire calculation, whether they counted 2 years excess or not.
My lord?
2 years excess is there. Whether that is counted or not.
No. It is counted. That what my submission.
So
The interest is counted, my lord, on.
That question has to go over, sir.
For that purpose, my submission is, my lord, here is that 34 years, my lord, the gratuity is calculated taking superannuation date. Instead, the dismissal order is taken into consideration. That is December 13. So then, my lord, right now itself, my lord, from the date of joining and this, what are the total years, it will come. Applied by, my lord, last drawn salary into 15 days. Comes to, my lord, that 9,39,000, it must be 8.5 lakhs or so, whatever figure comes. Based on, my lord, that the interest calculation 10% straight away for the delay. Up to deposit of 10 lakhs. So some interest comes. So that interest and the principal amount put together minus this, my lord, 10 lakhs deposited. Deposited after I have withdrawn.
So you are accepting for that amount of deduction.
Yes, actually, because that this is a mistake. We have the magnanimity ultimately.
Once you calculate that entire amount, I'll post them at next week. The issue is settled now. The proceedings office wrongly.
Whether he is entitled for interest part also is to be there.
You for your purpose only, you are.
I understand.
In the open court, we convinced that the proceedings are wrong proceeding. So that issue will go. Then, according to your contention, the matter will come the excess amounts.
Yeah.
So with regard to that, he is accepting that wrongly counted.
Minister superannuation data.
You prepare that portion, sir, kindly will post the matter.
And when we have deposited that interest,
up to calculate that, file that sheet, sir, will close the case, sir.
Lord, the ratio laid down by the Supreme Court came in only in the 2018.
You become a latest judgment, sir. It gives, anyhow, we are giving 1 week time, sir. By the rate of next week, to prepare that calculation sheet, if you have any latest judgment against supporting,
let always across the
liberty. Next week, sir. Next week for orders.
Anything.
17th.
Going off in 18, back on 3rd. I'm going to Kasi 10 days.
17th, it's okay for sir.
I have to send it to the department. They will calculate.
We'll try.
Otherwise, by Passover, I can also get calculate. So let the.
No, that should be an official way. Anyhow, the open court issue is decided. Only question reduction of the excess amount.
I only submit from 10 days.
We'll post that 16th, it's okay, sir?
17th.
Okay,
17th is working.
Post on 17th. Yes. On Friday, 17th.
For order?
Yeah, for orders. Molali Venkatesh. Yes, sir. Which other side, sir?
Lordship, services 2 is appearing.
Yeah, ready?
Lordship, counters are filed in this lordship. It can be taken up at any period, Lordship.
Next week?
When it was posted on 26th April 2020.
It can be taken up today.
His Lordship Justice E.V. Venugopal has posted it for orders. Then it disappeared from the list. Now again I made a mention, now it is coming up.
Don't disappear in this court, don't worry. Next week?
Yes.
You be ready for the next week. Next week.
Thursdays, because the government reader will be appearing for another matter as well, Lordship.
Okay, Thursday.
It will be convenient in that way.
Just preparing for petitioner, your lordship, for a section officer with chemistry.
What is this matter of B pharmacy?
Yes, your lordship. B pharmacy matter wherein.
Then what to do?
Your lordships have also heard this matter wherein B pharmacy is a qualification of petitioner, and the qualification required for the post of forest section officer is that chemistry as a subject or else any bachelor degree.
If your lordships will see the notification which is on page 9.
No, don't repeat. We'll once we decided the matter. He is from
They are formal party, my lord.
formal party. Who
Earlier,
has to appear for this case?
TSPSC.
TSPSC.
has to appear. In fact, in other matter, in other court, where that matter was specially mentioned case, nothing survives in that matter. In that matter, he appeared online and informed the court. But now in this matter, your lordships knows, my lord, it's coming for 5th or 6th time before your lordship.
Okay. Next week we'll take up.
Your lordship have it Tuesday for orders. At least by that caption,
Okay.
they might appear.
Today, when the matter is called, respondent counsel is absent. Who is Yes, sir. Ready, both of you?
Yes, my lord.
Small matter or big matter?
It's a small one only, my lord.
Oh.
My lord, this,
Matter about, tell me the facts.
my lord, this writ petition is filed challenging the in the labor court
Award.
decision, my lord.
What is the
Award,
labor
my lord.
court award?
My lord, that is dismissed, my lord, because
Nil award.
yes, it's regarding the cash and the ticket irregularities.
What is nil award? What is there to get?
Yeah, I know, my lord, but this struggle is going
Beyond
on.
the nil award, you are going to prove anything in this court?
I'm just coming up with the same prayer, my lord, for reinstatement and
What is it?
consequential benefits.
Reinstate. I think once this court is dismissed, same the ID where the ID award is nil award is there, dismissed. Why the entire thing was proved. If you want, I'll give one more week time. You prepare. If you are find out any fault in the ID award, we'll discuss. Or otherwise, this has to go now. Why? Because nil award is there.
The ID court manner dismiss the award.
Yes,
They also accepted the negligence matter.
Then
that's a long battle, my lord. It's coming up from
Correct.
2013 for the last 10 years. I have
yes, correct,
running
madam.
around the case.
Because of that, you can't reinstate. No? There is a law is there, provisions are there, act is there, system is there.
If I'm entitled for any consequential benefits, that may be considered, my lord.
Knowledge, sir.
Because he is the employee of the corporation.
No, you get instructions if how much anything is there going to get some benefits, some a positive answer. So they will little bit happy. Huh?
Yes, ma'am.
Next week? Next week.
Yes.
Yes, madam.
Lordship, counter is filed in this matter, Lordship, but we do not have the bundle because Lordship. Time will be given.
Post after 2 weeks.
We'll take it from the other side, Lordship.
2 weeks.
Watching 1 week.
1 week. I'll seek the bundle. I've already asked.
Post after 1 week.
Obliged to.
May I please, Your Lord? Madam Lord.
Both sides ready?
Thursday, Lordship.
Thursday ready, sir? Post on Thursday.
The learned government pleader will appear on Thursday, Lordship.
So inform him. Just simply you are asking time.
Yes.
They are
No,
accepting.
I made
And
it.
again,
There,
it will come.
twice or thrice.
Again, don't do this exercise.
I made it a point to make it on Thursday. Lordship.
You are right, very good for that.
Yes,
But what I'm seeing, this court is asking you, made a represent, ask him to attend next date of hearing.
Certainly.
Yes, madam. You are for revenue. Yes, madam. Ready?
So, non-speaking.
Ready?
It's a non-speaking.
Not ready? Ready. Then when do you want? Okay. We are posting on Friday, madam. Kindly attend on that day and we'll close the case.
The matter pertains to the pension, my lord.
Uh-huh.
The only, that's why there's some urgency. Is without pension, my lord. The SY village officer, my lord, original appointed in 85. That time in 1991 as a VO.
2018 matter this one.
18 matter and pension is without pension.
Yes. Okay, we'll see on Friday.
Yes.
So, next, madam, next date of hearing, please ready. Pension matter this is.
Lordship, it is service matter, Lordship. She was of the opinion that it was non-service. Apologies for that, Lord.
No, even otherwise also.
Thursday it may be taken.
2018 matter,
Lordship.
Thursday, pension has to get.
Yes, Lord. It may be taken up on Thursday, Lordship.
Okay, post on Thursday.
Representative Pitti Koteshwaram, Lordship. Can you request 4 weeks time, Lordship?
Okay, post after 4 weeks in usual course. From the caption of special identified matter.
Lordship, again the award of the labor court, my lords. The facts of the case is like that one lorry bus went.
Who is other side?
Gaddam Srinivas, I informed, my lords. I informed.
He'll come now.
I do not know. I informed, my lords. I'll only just take 1 minute. While giving a way to a lorry which was coming opposite direction, the driver went and hit a garbage bag in the night. When they opened a garbage bag, there was a lady present in it.
Lady?
Lady inside the garbage bag, who was a mentally retarded person, was inside the garbage bag. It's an admitted fact. Lordship, may kindly see page 16 months. I'll only read one para.
Gaddam Srinivas' name also not printed.
I informed him. Lord. It is to be noted, 16 page.
What is the relief you're asking? What is the punishment?
Attendant benefits and back wages denied by the labor code.
What?
Attendant benefits and back wages denied by the labor code.
On the ground?
On the ground that I was partially responsible.
For what?
For this accident. For hitting a garbage bag, for causing injuries to that mentally retarded person inside that garbage bag, I am responsible. So partially responsible is what the finding. Yes. Only one page I will read.
What's wrong in it?
My lordship, it's a garbage bag. I'll read once and your lordship will see.
No garbage, okay, you are out of coverage area, but fortunately, unfortunately, one lady is there in that house.
Inside garbage bag, how will I know that a person is there, my lords?
No, even. No.
I'll just read one page. Page 16.
No need to say your whatever I am believing. Your contention.
This is the report. This is a report filed by them.
Say once it's a garbage bag. In the garbage bag, there is no person you could not punish.
Correct.
If it is a garbage bag, there is a person inside the garbage bag. Some injury is taken place. You are also.
According to them, my lordship, that garbage bag was there since 2 days. The person has already died. In that garbage, someone has thrown on the road. That is their report. I'll read just one.
Where is it?
Page 16.
Page
16. Finding of the court, quoting their own report.
Yes.
16. Unnumbered para 1. It is to be noted.
1 second.
It is to be noted that the involvement of petitioner in the accident is admitted. Whereas Exhibit M1 shows the head constable APSRTC Nargitpally submitted report that one mentally retarded lady dashed the front left post of the bus and died on the spot. The star document clearly shows the conductor mentioned that one mentally retarded lady covered in a gunny bag sat on the middle of the road and the driver while giving way to lorry dashed a gunny bag. The driver has given the statement that one gunny bag was kept on the road for the last 2 days. The preliminary inquiry report shows that lady slept on the side of the road by covering a gunny bag and she looked like a garbage on the roadside. Clearly shows that admittedly mentally retarded lady slept on the middle of the road covering a gunny bag. Direct evidence stated that it looked like a garbage. Direct evidence shows that it looked like a garbage. The direct witness has not supported the case of the management. The conductor and driver categorically stated the same. The manner and mode of the accident clearly show that in the night, Lordship, in the night, the mentally retarded lady slept on the road by covering a gunny bag. Admittedly, it seems that in the night it looks like a garbage. Ratri puta. Therefore, it is clear that petitioner is not solely responsible. How am I responsible is my case. Garbage, my lords. Ratri puta. I understand. It's a person, light is there, someone is hiding behind the garbage or someone has thrown the body there and gone.
But
and criminal case, my lord.
Stated body is not a dead body, that is a live body. They
Lordship, that
slept on the road with the gunny bag.
The other witness also
By
stated
seeing the gunny bag, you understood it's the gunny bag.
there are two kinds of evidences here in very same.
No, where is he? Gaddam. Gaddam will come to decide the issue.
I in fact, the Lordship, after observing the court proceeding, I'm informing them that so and so item number is yours. Please come. The judges asked me to inform. I'm informing them. What more can I do? Kindly.
Post Tuesday.
Yes.
Same matter. Tuesday.
Approved by the orders of punishment, my lord, the petition is filed, my lord. Transfer.
Yes, sir. Services 1 is there, na? Services 3 has to appear. We direct the registry to print the name of services 3. Post next week. Ramesh Pura. One appears post after 2 weeks, equal course.
Yeah, I am for the fourth respondent.
Rapur Bhaskar. None appears post after 2 weeks.
Blessed.
Lordship, item number 5.
Item number
5. Apologies for not tender before the decision bench. Number 5, contempt of justice with the Lordship. We have filed review on that. You can share the assignment transfer. It may be taken up with the review.
I think 5 was adjourned to
Pass.
pass over adjourned.
Inside the church.
Pass over. Filed review petition.
Review petition is filed, Lordship.
Okay, along with review not listed, na?
Not listed, Lordship. I'll share the SR number, Lordship.
Along with review post next week.
SR 89.
Okay, we'll give some time. Once review will come in the list, we'll see. We'll attend the matter for another 2 weeks or 1 week.
2 weeks, Lordship.
Okay, post after 2 weeks.
Your lordship's consideration. No, my lord. Item number 3, my lord. I love, my lord, first matter in DB, my lord, DB3. Your lordship. Dismiss for default, my lord. Matter relating to selection, my lord. Selection and appointment, my lord.
So file petition, take up immediately without any mistake.
Organized.
What did you say? 8? Anybody is there? Secondary gallery? Tested, but you are disqualified. So it go. So we'll say just nothing, infractions. Item number 8. Item 8, learned counsel for the petition informed this matter becomes infractious. And giving liberty to the petitioner counsel, if any rejection order passed by the authorities, he can approach the appropriate forum. Item 6, Passover. Passover is done. అసలైన లేడు మిగతా అందరు కానీ దేనికి పాస్ ఓవర్ అయింది అది ఇన్స్ట్రక్షన్ తీసుకొస్తా అన్నట్టున్నాడు లేడీ గారు. ఓకే
None of this.